Yes.
Supplementary list. Item number 1.
Flip ini. Flip ini. Tadi. Yes, also appear in this matter. State, Mr. Khan.
State is supposed to file their affidavits.
They have not filed it. Why?
Lordship, if I may just submit, Lordship, we have received the Parawise comment.
That doesn't help anything, Mr. Khan.
Lordship, the contents.
We can go along with it. We can take that on board and pass orders.
No, we have received the comments, the Parawise, which are basically no comments. We have written back to the department.
No, what is this matter is regarding?
Lordship, Lordship, this is regarding.
Matter is regarding the weighbridge, my lord.
Weighbridge matter. Another PIL actually had addressed the issue at length.
Through the weighbridge rules.
My lord, the issue is this, my lord.
Yes.
There is a claim of the private respondent that he has lifted X quantity of coal from East Jayanta Hills, my lord. Then we file an RTI, my lord, to find out how much quantity of coal has transported to Garo Hills, my lord. He has showed X quantity of coal has been exported from Gasopada, my lord. Now, in the weighbridge, different weighbridges, where he has transported the coal, my lord, the trucks which has ply, my lord. In the weighbridge, none of the coal which was exported, my lord, was shown, my lord. We have a serious doubt, my lord, that those coal are illegally extracted and transported by just manipulating the papers, my lord. And
what orders have passed by this court earlier on?
Only notice, my lord.
Only notice.
You filed that affidavit. When can you file it? Within 1 week?
Lordship, what we received was very surprising, Lordship. We have written back to the department. In most of the paragraphs, they have just given a comments, no comments. So we have written back to them, kindly.
Officer concerned?
We are not in the position to file because of no comments. And Your Lordship, is another matter connected, illegal, the weighbridge matter in another PIL. And what my learned friend was submitting, Your Lordship, that was prior to the weighbridge being put in place, all this thing had happened. So that PIL has been disposed of and all the weighbridge are in place, system is in place. So Lordship,
then you file an affidavit, at least we can adjudicate the matter
Lordship,
fully.
but so far this PIL is concerned, Your Lordship, we received no comments, so we were not in the position to file. We have written back
Are
to the
you
department.
meaning to say it's come infructuous?
No.
On view of this
Absolutely, Lordship.
disposal of the other case?
Absolutely, because
But he's flagged a specific issue with regard to certain number of trucks which are carrying, which didn't reflect women's slips.
absolutely, that was the situation when there was no weighbridge.
No, there is not a correct position, my lord. State is not giving the correct position. There are number of weighbridge. In Pramile, there is a weighbridge, my lord. Forget about the Garo Hills weighbridge, my lord. My lord, what about the Pramile weighbridge, my lord? From East Jayanta Hills, which is coming, my lord. It is functioning. What about the Nongpo weighbridge, my lord? Umling weighbridge, it is functioning. But they say that, my lord, no such coal has been transported.
You file an affidavit.
Lordship.
Just, in spite of accommodation being granted by Order 1810/2023 to the state respondents to file an affidavit in terms of the order dated 31st August 2023, Mr. K. Khan, learned EAG today expresses difficulty in view of the difficulty and submits that the instructions received were incomplete. Stop. Next paragraph. This matter has been pending for affidavit since August. It's expected by the next date the affidavit should be on board. We listed up to 2 weeks and so on. Yes.
Item number 2.
One second.
My lord, in this matter, may I make 2 prayers?
1 second. Yes, please. Have you filed an affidavit?
My Lord, I was unable to file. Just make one prayer.
Yes.
Now, we have reviewed the entire reports, more than 10 reports they have submitted. Now, they deal with the long-term, mid-term, and the short-term. Well, they go for mid-term and long-term. With regard to, my Lord, the short-term, they have given commitment for the last 2 years that they will complete the choke points, traffic choke points within 7 months, 4 months, many areas are there. Now, the petitioner came to know that nothing has been happened. So may I pray, if Lordship allow him to visit, take the status photo, place on records, my Lord, whether the government commitments given before this Honorable Court is in action or not. My Lord, for that I need two weeks' time.
So if we correctly remember, I think it's on pointed is regard to NH6, correct?
My Lord.
No, this is not.
No, it is a traffic matter, traffic congestions. Traffic congestions.
What's the different one? Okay.
Traffic congestions.
In the last day, the suggestion came from the court whether this committee.
That was one of the prayer.
Oh, yes. That
is one of the prayer.
Right.
A member should.
Sorry. Yes. Okay.
That is one of the first prayer. Second prayer would be, my Lord, regarding the formation of the Shillong Decongestion Committee. My Lord, the writ petitioner made some effort, and he found that there are some experts who are expert in the field of town restructurings.
Who's that?
My Lord, decongestions, my Lord. May I please a few names, Lordship, may kindly.
May I submit
Mr.
the
Advocate General.
May I complete? I request Mr. Leonard AG to complete.
Yes.
My Lord, 3 names, my Lord, I've suggested, my Lord. Dr. P.S. Pangne, former Chief Planning Officer and ex-officio Joint Secretary, Government of Meghalaya, Planning Department, and specialization in advanced transportation planning, including traffic decongestion measures. Number 2, such and such, qualification MTech in infrastructure system, such and such. Number 3, Mr. Dominic Mellor, qualification PhD in transportation engineering, IIT Guwahati. These people are in fact concerned with the restructuring and the decongestion. Their feedback would be really, my Lord, essential for the committee, if Lordship consider them.
1 second. You don't have anybody who's like who's got expertise in in this what do you call it, sort of not town planning but something related to that with regard to because this, you see, the first one, he's chief planning officer, he's with regard to planning. Is different. Second one is we don't know this person, infrastructure systems. So whether he's appropriate, and the third one is qualified PhD in transportation engineering. What is transportation engineering? It's different from, it's it has to do with it has to do with
As far as the information,
it has to do with what do you call it, traffic movement, town planning, that kind of thing. Even traffic management systems also.
my Lord, that is
who work in that field.
my Lord. And these
But
people.
I can just say off the record, like a long time ago, then I met an acquaintance. So only he's in America or whatever, but then he was a PhD also. And so for Rome, Rome for Italy, their university was engaged, in doing the traffic management and putting where traffic signals would cover what places.
Yes.
And it seems the study they had to do was so intense,
Yes.
because they have to measure, they have to see, at what point of time the traffic is this much, where the traffic is coming from, what is the source of traffic. So he said that, it was such an exercise which, is not a small exercise.
Yes,
To put in place a software that will manage the entire traffic signal so that the traffic flows evenly.
Yes.
So we need someone who has some expertise, in traffic flow management, or who has somehow maybe, yes, Mr. Arvijan.
Yes, Lordship, we have engaged the consultant, international consultant, and we have placed one report, my Lord, of the traffic management, the volume of traffic, the issues. Your Lordship, kindly see my affidavit precisely on this issue. My affidavit of the report is also annexed with that. Your Lordship, kindly see.
I don't have a general person, just a general public spirited person who faces the traffic congestion every day, part of the committee, which can be any lawyer out here. Yes. I prefer
16 March 2022 affidavit,
Yes.
16 March 2022 affidavit.
16 March?
2022 affidavit. Along with
That's too old. That's too old. We're not going to look at that.
So you'll also
I think
we are concerned.
So it'd be better if we put one advocate from here to sit at the committee.
Yes.
Your Lordship, can you see the report?
Madam.
Can you see the report? Expert committee report. Can you see the expert committee? Delbert is how they have placed that thick volume also, my lord. Can you see that expert? How much? Because this report was referred to IM Shillong for comments also. Based on
Listen 1 second. Your affidavit dated 23/6/2022.
16th March 2022, my lord. This is the affidavit dated 16th March 2022.
Well, this is only a report. Here we are not.
It's
only a report.
Let me finish because multiplicity of authorities will not help us because that's the issues which have been identified in that, and it is very extensive report and it has been prepared after detailed research.
This on 18 April.
16th March 2022, first page says, my lord. First page of my affidavit further states the report on behalf of state government to Secretary, Home Police Department and Compliance 16th December and 17th February, my lord.
Yes.
16th March report. And your lordship, kindly see the issues which have been identified at page 2. Identified issues and proposed solution, my lord. Lordship, got the report?
Yes, I've got the report.
Yes. Now, your lordship, kindly come to page 2, paragraph 7.
Yes,
it is respectfully committed that first page of the first stage of solution to the issue at hand is determination of problem areas which requires the attention. That being cognizant of the issue of traffic and the state government proceeded to services.
So what happened after this?
No, may not. Then thereafter, your lordship will see the page 4. Page 4.
What happened after this?
So, in terms of the recommendation, various stages, solution has been suggested and measures have also been. Kindly see the areas with the research which have been carried out. After research, then we have carried out the various graded plan, my lord. If your lordship will see the first stage, that's why I wanted to show challenges addressed. First is congestion in Police Bazaar and Bara Bazaar. Your lordship got the tabular form at page 4.
Yes,
26% trip in the city are for shopping, mostly directed to Police Bazaar and Bara Bazaar. 70% of those trips occur by car. Solution suggested next door markets or farmers markets.
This won't do because this won't do. People in Shillong different. They only go to Police Bazaar. Whoever made this report has no idea about
What has happened, Milan? What has happened?
Police Bazaar are the place of choice. They should find a solution how traffic moves smoothly towards places.
Exactly.
This first one, even layman Shillong will say no.
Right. You have to kindly see what we have done is kindly come to page 7 below. Kindly come to page 7.
See, come wait, just wait, Mr. Advocate General. Number 5. Okay, see this peak hour congestion near schools. This is a very, very important point. And you put in the school buses, and there's been no awareness about school buses or the safety that begin to students. So no one's using the school buses you bought.
I'm really pleased to inform that now, because of the awareness generated, the occupancy has gone up, and that data. And earlier there was an issue with regard. We had several rounds of meeting with parents, teachers, school management, and now numbers are increasing, day by day. This kind of awareness, I can place that data also, because recently I was shown that data. That awareness is...
That data is that page 5 of the latest report. Page 5 of the latest report, the data of school bus.
No, what's that? What orders were passed when this detailed report was filed? What orders were passed?
After this,
my lord, nothing was passed. They give this government, they place the reports, consultation with the experts, and down the line, my lord, in reality, nothing happened. Now we are concerned, my lord, according to the view of the petitioner, we are concerned about the implementation in reality.
So that means the petitioners have been vigilant also.
My lord, nothing is happening.
If the report generated, that means there must be some forward action.
Paragraph 11
nothing is happening.
Mr. Advocate General, no point reading. It's like having a paper tiger of a team.
That is going on.
My friend is saying nothing. So that's why I have to answer this page. Kindly see paragraph 11, page 7.
On paper is very good.
No, Your Lordship, what we are doing is, because of these measures only, we have got the school buses, we have got widening, we have got, these are the measures which we have suggested and we are implementing it, my lord. And as and when fund is getting generated also, my lord. So if Your Lordship will see, and the areas specific intervention. So now this is part 1, city, you also will see various, then in detailed road map, my lord. These maps, these details are being, my friend has not filed any reply refuting that we have not done. He stands up in the court and nothing has been done. Your lordship has directed my friend.
We are seeking that he has filed a number of reports.
Last time also, lordship directed my friend to file affidavit, sort of affidavit, coming back to my affidavit. He has not filed and he will stand up and say nothing has been done. Let him point out what has not been done. Because he said that nothing has been done early and we accepted nothing has been done. My lord, we have
See, Mr. Advocate General, this is not adversarial. We are all here on common cause and common ground. That you see, all facing congestion. Lawyers are complaining they can't get to court on time. They have no reasonable, excuse that they were stuck in traffic. It's happening every time now. The senior counsel is on his way. He's stuck somewhere.
I'm not denying, my lord, that the problem is not there. We are trying to find out the solution for which we have got the 3 expert committees. They have done detailed research, and my friend and we are implementing it. Let my friend point out in what area we are having shortcomings.
If Lordship keep me, I will definitely point out.
Mr. Advocate General,
what is act on that? We will act on that.
You tell us what is the progress report till date.
Yes, Your Lordship, kindly see time to time various progress report. Last progress report, Your Lordship, kindly see 14th November, my lord. Kindly see the 4th one, because we have filed several progress reports, my lord.
Lordship, 14 November, page 5.
Mr. Advocate General, I mean, this time those submissions not necessary right now. We'll have it at a later date. Because if you're going to ask for an audit of what has been done pursuant to the report, then that involves another exercise. Okay. So the thing is that as on today, you want some time to file a reply. You file a reply.
Yes.
Take down Mr. H.S. Reso on the latest status report that will file a state respondents on 14/11/2023 seeks further time to file a short affidavit. Stopped. Next paragraph. It has also been brought notice of the court that repeated reports, numerous reports have been filed with regard to the status of traffic and steps that have been taken, which include the engagement of professional agencies to enable traffic management. Stop. Next paragraph. However, situation as it pertains on the ground, there seems to be hardly any improvement. In that view of the matter, after the affidavits filed by the petitioner, the matter will be taken up further consideration. We'll pass orders on the next date. This is matter on when do you want it? When, after how much time?
After 10 days, my lord, if she permits.
After 10 days, yes. It is noted names of certain persons who has been submitted by Learned Senior Counsel for consideration to be the independent member of the decongestion committee. The same is taken on board and be considered on the next date. Yes, you have other name, but this code, I don't know, but is fearful of putting an advocate on.
But even I suggested with Lordship permission, Learned Senior Counsel, Mr. Titi Ting Do, my lord, that would be really a help the committee also for independence, my lord.
That we will see.
In the last occasion.
That we will see.
Yes.
Yes.
I do.
Hearing, supplementary list.
Please.
Item number 2.
Number 2.
There are three accused.
Yes. This is the appeal against conviction, Your Lordship, passed by the District Judge Chuai.
Yes.
Please, Your Lordship.
Yes.
First and foremost, my Lord, I'll go to the charge.
Please start.
The charge was framed under Section 302, read with 34 IPC against all accused persons. Originally there are 5, but 1 died. So ultimately remained 4. And ultimately another died, thereafter another died, and now remain 3.
When did the incident occur?
On 10 July 2006.
Okay.
2006. Maybe.
I got a paper book.
Another page.
Was this heard?
I invite your Lordship attention to page 26, Madam.
Was this matter heard by the other bench?
Pardon, Your Lord?
Was it heard by the other bench?
No,
As
no.
hearing comments, want to know. First time.
First time.
Yes.
'26, my Lord, is a charge.
Page 26.
You're referring to
26.
the
Paper
And a
book.
type copy,
You're referring to the paperwork.
yes, paper book,
Type copy, page 27.
page 27.
Yes, please.
Yes.
At outside, my Lord, I would respectfully submit that all these appellants, they are illiterate. They are illiterate. They are poor and illiterate. Regarding their economic condition, it has been reflected also in the report of the police also. All of them are less than income is less than 500.
Mr. Kinche, I believe, I think you should go from first the facts of the case. Refer to the FIR first. You have jumped to the chart. What does the FIR say?
Rightfully, my main contention will be from the charge, Your Honor. The fact of the matter is that the accused were charged that they have committed an offence. They have killed one of the deceased, Madam. That is the fact of the case, Madam. And they were framed under Section 302, Madam. Read with 34, Madam.
We are still not going to the facts of the case. How did this?
In that case,
how
I'll
did
go
this
to the
story
FIR, my Lord.
evolve?
I'll go to the FIR.
Exactly.
Oh. Page, huh? Page 3, my Lord. And type copy will be in page 3 and 5 also. In, translation one will be on page 5, Madam. Shall I read it? One shall be Rakai, my Lord, has lodged this complaint to to the police. A translated copy is on page 5. Against Dalip Salman, Mud Rakai, Tum Rakai, Mulo Rakai, Yola Rakai. Sir, I, Kacharbi Rakai, mother of Sri Yalong Rakai, who was murdered, humbly request you to arrest those person that was named in the subject above for the reason that they have murdered my son, Sri Salong Rakai, in my residence at Natiang at 7 p.m. on 10/7/2006. I cannot come to report the matter before you since the murderer prohibited me to inform you. They threatened to kill me as well. I am just a powerless woman. I pray before to ask them to cremate and correct the dead body, as I am unable to do it myself. In the future, to protect me from the cruel person. I will be forever grateful for their kindness. That is FIR filed by the murdered man. And the police have registered the case. Yeah. In page 6 also, madam, the police has received the Joy PS GDE entry number 286 detailed so-and-so at 3:30 p.m. and registered by Joy PS case number 81 within bracket 706 under section 30234, and Sri SIC Lamari has taken up the investigation of the case, madam. So that is the fact of the case, madam. And after the investigation, they have sent this 4 person, of course, one died, to the court for trial before the court of district assessment judge. And now I'll come to the charge sheet, madam. Charge sheet is in page. Charge sheet is in page 7, madam. And the type copy. Charge sheet is in page 26, and the type copy is in page 27, my lord.
1 second. Yes, ma'am.
Yes, please continue.
Type copy, madam. Simchi Bikiri, Session Judge, Western Hill District. Named the accused hereby charged Mud Rakai, Mulo Rakai, Thum Rakai, Yola Rakai, and Dilip Sharma. That one died, of course, my lord. That all the 5 of you as follows. On or about the day on 10/7/2006 at 7 p.m. when and murdered Salong Rakai, son of Sharbi Rakai, at the residence at Natiang, and thereby committed an offence punishable under section 302 34 IPC, Indian Penal Code, within the cognizance of this court, and I hereby direct you to be tried by the said court for the charges. Then charge read over and explained to the accused. Charge read over and explained to the accused by Sri R.B. Hing, advocate, in Pnar language, and accused Mulu Rakai, Yura Rakai, and Mud Rakai the same page, my lord. It is in the top. Pleaded guilty.
One thing, Mr. Kenjing, sorry to interrupt you. From what, from this, when the police were magistrate, then they recorded a confession statement, correct?
Yes.
And then there they all confessed voluntarily that they had committed the murder.
Except what?
That is why you're making submission that they're illiterate and they know.
Yes.
But they were explained, I think, as to the what will be the, you know, what will be
I explain, my lord.
effect of, you know, this.
I explain. Not all of them pleaded guilty. Dilip Sharma pleaded not guilty. But this accused died after during the trial.
Out of 5 accused, 2 have already died.
Died. And only 3 remain.
2 died.
2 died.
2 died in the year 2018, Your Lordship, during the course of trial.
So 4 said that they pulled him out, they wanted to give a statement. Then that they beat up the deceased with hammers, stone and sticks. Then pulled the deceased to the road and killed him there.
Yes. I'll come.
Then we'll go to statements, yes. Yes, please continue. Just this observation that, you know, yes.
In this case, that's why right from the beginning I have stated,
the illiterate.
because this I have submitted earlier also before the previous division bench, that all of them are illiterate and they are poor. And their income also is less than 500. That is on record. Page 14, of course, regarding the income, my lord. This is page 14, my lord, regarding the income. Income group. All are lower income group, below rupees 500 per month, my lord. So they are illiterate and they are extremely poor. And their occupation, of course, is cultivator, my lord. So in this case, my lord,
Yes, sorry.
So in this case, my lord, the accused are illiterate, but in this matter there is no interpreter. When the charge was taken up, my lord, the charge, well, there's no interpreter. Though they said that it was it was done by the counsel. I'll come to that also. There is no evidence to show the presence of interpreter, my lord.
You mean to say that whoever presiding officer was there could have explained in native language?
But in that case, if they just a language, my lord, there is nothing but a translator only. But Section 281 on all the provision laid down in the CRPC, it's not just a question of translation. It was done, of course, by that counsel, my lord.
You're talking about the charge, or you're talking about the statement under what 6?
Now we'll start from the charge, my lord, because if the charge goes, everything goes.
Okay.
There is no interpreter. There is no evidence to show the presence of interpreter, and if he is interpreter, my lord, then the procedure has to be taken up. He has to take oath also. There's nothing on the record to show that.
Yes.
So the charge by itself is illegal, my lord. Now, if we go to that charge, my lord, what is stated that you on or about the day on 10/7/2006, 7 p.m., when and murder Salon Rakai, so and so at the resident at Natia. Then charge read about and explained to the accused by Shri R.B. Hing, advocate in Penang language. And accused so and so, accused Mulu, Yolang, Mut Rakai, pleaded, Tan Thum Rakai pleaded guilty, while accused Dilip Sharma pleaded not guilty. So if you go through this line, my lord,
Yes.
there is nothing to show that he has explained to them, to the accused person, my lord. There's nothing to show if you go through the charge. We are saying that it was done in the presence of the.
This is the observation of the this is the noting of the presiding officer
Of the judge, my lord.
of the judge.
Yes. She said that
The charge read over unexplained.
nothing to show that they have explained. There's nothing. It was just in a very perfunctory manner was written in one line, in 1-2 line. There is nothing to explain.
Where's the procedure which says that this is defective?
281.
281 is the format for the 164 statement.
It does not include only 164, my lord. It's for everything. Let me go through my lord. Then we'll bring to your lordship attention. 281. Record of execution of the accused, my lord. Whenever the accused is examined by a metropolitan magistrate, the magistrate shall make a memorandum of the substance of the submission of the accused so and such memorandum shall be signed by the magistrate and shall form part of the record, my lord. Whenever the accused is examined by any magistrate other than metropolitan magistrate or by a court session, the whole of such submission, including every question put to him and every answer given by him, shall be recorded in full by the presiding judge or magistrate himself, or where he is unable to do so, owing to a physical or other incapacity, under this direction and superintendent of so and so. Then the 345, my lord, very important. The record shall practicable be in the language in which accused is examined. If that is not practical, in the language of the court. This was not written in Pana language. The record shall be shown or read to the accused if he does not understand the language in which it is written. It shall be interpreted to him in a language which he understands and shall be at liberty to explain or add his answer. Thereafter shall be signed by the accused and by a magistrate or presiding judge who shall certify under his own hand that examination was taken in his presence and the hearing and that the record contained a full and true account of the statement made by the accused. So, if you go through 345, my lord, there is nothing to show that the magistrate is, the session judge has satisfied herself. There's nothing. In 282, my lord.
This is very clear. The noting at the bottom of this page clearly conforms with this clause 5, subsection 5.
Confession statement, page 80.
When yes, come to confession statement also. Okay, this is at time of.
I'll come to that. I'll come in by stages, my lord.
Page 80.
Because charge read over and explained to the accused. Where is the explanation, my lord? There's nothing.
Charge read over and explained accused by C.R.B. Hinge, advocate in Pra language, and accused so and so and so and so and so and so, while accused pleaded not guilty. The very fact one of them pleaded not guilty, that means they understood the charge explained to them. If we all just nodded all of them, then maybe, they didn't understand. But one pleaded not guilty. Anyway, continue.
But the fact
So you
remains,
feel
my
that
lord,
this is
it is on record.
This is fatal to the entire case. The non-recording of that's not recorded in the native language of what they said
that
exactly.
I'll come step by step. That will be one of my crown, my lord.
Okay.
Judge read about and explained. There was nothing to show that he has explained anywhere by R.B. Hing advocate in Penal language. And another thing also, my lord, there's nothing to also to show. The R.B. Hing has not signed. The advocate has not signed also here. How can he? And he was not examined also.
Yes, please go.
Which year? Which?
The charge has been proven.
One thing, Mr. Kenji, the incident happened 2006, correct? 2006,
Yes, madam.
July. And the charges were in 6 May 2014. 8 years after the incident.
Yes. And
My
the way the charges in frame in July in the session court is just like in the bazaar only. All the accused will be put in the dock, and then they will be called their name, and read the charge, and then raise the hand like that only. It's not systematic also.
yes.
It's always like that. It's very crowded inside the courtroom, and they are all called, and then they call the name, and then raise their hand. Where is the fact that they have been explained? And where is the scope also? The July court is just nothing but a very crowded, just like in the shop only, in the crowded shop only.
Okay, good. That is besides the point.
This is really
Mr. Kenji,
objectionable,
I agree.
Your
I mean,
Lordship.
that is was a shop or a bazaar.
Really a disrespect, in my humble respectful submission, Your Lordship, that is a disrespect
No,
to
Mr. Shula is
the lower
okay.
judiciary, Your Lordship.
I explain. Because this is a case conviction, my lord. This is case conviction for life. Then I have to bring everything, because the case, of course, the case is a continuation of the struggle, my lord, because he has been convicted. So I have to show all the fact, because the condition. That's why I bring all those things right from the beginning. And how the case has been occurred in 2006 and
15 on to 16.
You are on a technical point, so please.
now I'll come to the technical point also, my lord.
20 at the deposition time.
Let's go straight to confession, Krishna.
6 years took for because depositions. This is normal. 21. Make it this.
In this case, my lord, wait, yeah, don't be in a hurry. Your turn will come.
So in this matter also, after the charges were framed, then the deposition also took from 2014 to 21 to be recorded. How many PWs were there?
8, Your Lordship.
And defense witness?
In this case, my lord, as a matter of fact, so they were convicted. There is no other evidence except confession, my lord.
When we'll examine that aspect only then.
But no, that's why I'll deal in confession thoroughly, my lord. The confession, my lord, was done in page 80, my lord.
We'll go to the charge of adjustment with you. Sessions go.
Lima tu ke dekat dengan you. Saya tu berperkara Krishna.
7 years, 8 years contraction. After Contempt, 21. Forensics, I don't think just going on confession statement. Yes.
So what's your next point?
Now we have come to the confession, my lord. In this case, my lord, the confession, first and foremost, I have to show that there is no interpreter in that confession also. There is no interpreter. And in this case also, when they were first brought before the then trial to record the confession, that means the magistrate first class, he granted, of course, 1 day judicial custody as they were brought from the police custody. Then after, but if he calculates the timing, my lord, it will be not be less than 24 hours or so, because they were brought again, and then when they were brought, where do you put them? When they produce them before the magistrate, then they send them to the PI.
No, what relevance will that have? If the magistrates explain to them in their native language that, look, you are making the statement, you know that, whatever statement you're making now is not for the police, for the magistrate, and it can be, used against you. Now, if that has been explained to them, if we can,
my contention, man.
If that's explained to them, and even in the, now we have seen admissibility of that. That's all.
It is not a question of Rajan, when they were brought before the magistrate, then he sent them for reflection and he sent them to the PI. So the law is very clear that they should not be sent to the police.
Where is that?
Next to you, man. No? 32. In page 42, my lord,
Yes.
the deposition of the magistrate is very clear now.
Of the?
Paper book.
No, whose deposition of the magistrate? Yes.
Magistrate. I joined 7th year 2002 and presently posted at East India as additional deputy commissioner. In the month of July 2006, I was posted as EAC Magistrate First Class in the Deputy Commissioner, Jenta Hill District. The case was endorsed to me on 12/7/2006 by the Leonard ADM FM for the recording of the statement of the accused of all for under section 164. I fixed the case for recording of the confidential statement on 13/7/2006 and remanded the accused to 1 day judicial custody, since I seen the accused person were brought from police custody. Then, my lord, on 13/7/2006, the accused person were brought before my office at chamber at 10:30 a.m., 11 a.m., between 10:30 and 11. Then I explained the accused person briefly the procedure for recording of the confession statement, and then I sent them back for 2 hour reflection, and and they were sent back to the PI room, my lord. It's there in the record.
Your statement is so congested, there's no place for him to go.
No.
Can't be sent to a tea shop.
No, my lord. That is not the thing. This is the case of magistrate first class. That one which I've said just now is regarding in the court of the district and session judge. But this is now in the court of the magistrate who record the confession. And what did he do when you were brought to him? He sent them for reflection to the PI room. There is no room in July, my lord.
Okay.
There is no room. And they sent to the PI room. I sent them for 2 hour reflection, and we are sent back to the PI room, and have also sent my attached peon to accompany them and to be with them. Then the accused person was brought before me in the afternoon at 2 p.m. And this peon was not examined, my lord.
Okay.
Then each accused was brought to me chamber one day after the other, one after another, and I record the statement individually. I first started with recording of so-and-so. So, my lord, it is not denied the fact that all of them were sent to the PI room. That means it is contrary to what the law laid down, that the police should not be in the picture, my lord.
Yes.
So in this case, my lord, also, I would like to refer to the citation from the Supreme Court, my lord. I have included this right from the first.
You made a compilation?
Yes, my lord.
Very good. Yes.
Page one also, page one. Page one, my lord.
Yes.
This citation, Chip Bapa versus State of Karnataka. The magistrate who is entrusted with the duty of recording confession accused coming from police custody or jail custody must appreciate his function in that behalf as one of the judicial officer, and he must explain judicial mind to ascertain and satisfy his conscience. That statement the accused make is not on account of any extraneous influence on him. That indeed is the essence of voluntary statement within the meaning of Provision Section 114 and the rule framed by the High Court for the guidance of the subordinate court. Moreover, the magistrate must not only be satisfied as to the voluntary character, he should also make and deep such material record in proof for the compliance with the imperative requirement of statutory provision as to satisfy the court that certain judgment of the case, and that the confessional statement was made by the accused voluntarily and the statutory provision was strictly compliant. From the memorandum prepared by the municipal magistrate, as also when decision recorded in the court, is further revealed that the magistrate did not lend any assurance to the appellant that he would be sent back to the police case in case he did not make the confessional statement. Broadly, I will say, madam, because number one, they should not be sent to the police, and the police should not be pictured, and he should show also that it's a voluntary statement. And not only that, he has to show also that he has explained to the accused person brought before him that the consequence of his statement, and the consequence of his statement, that.
So according to you, all these are failing. That cannot be explained.
Yes, did not explain. And that I'll come one by one, my lord. That is from the decision of the Honorable Supreme Court, my lord, and which has been followed by other division bench also. I have made a compile, my lord. In the division bench of Jammu and Kashmir also have strictly follow all these provision laid down by the apex court, my lord. In this case, first to the police, and then when they brought to them, did not explain to them the consequence of their statement, and this has been from the case of Ravindra Kumar alias Dara Singh versus Republic of India.
State magistrate we saw just now, which you read, he said before he started recording, he's explained to him that it's not a police magistrate, briefed him whatever confession he makes, the law takes its own course. So that...
Where is that explanation is sure? It's a mere, he has mere follow the guideline laid by the High Court, our Honorable High Court. Otherwise, there's nothing to show that he has explained. There's nothing, a mere translation, and then he... nothing. And there's nowhere to show that the consequence of his statement, and that is what is in the case of Dara Singh. That is a stay, in that murder case in...
George Staines in Orissa.
Staines, yes, in Orissa. That is in the report.
Let us go to the 164 statement. Where's the 164 statement?
Page 80. Page 80.
It's 80 of the...
Yeah, this one.
See, Mr. Kanjing, what is
You see, I am a magistrate, and I have briefed him that whatever confession he will make, the law will take its own course. That's all. And the statement would be voluntary. I have also asked from the accused whether he has been tortured by the police. I have also asked him whether he understands it's up to his discretion.
So that means, Mr. Kenji, your whole case is hinged only on the confession statement.
Yes,
So it's
and nothing else.
Nothing else.
Nothing else.
That
So
the
if the
with
confession
form of
goes-
recording, they were not explained, and the consequences. They were taken back to PI room, which amounts to sending back to police custody.
Yes.
Do you mean to? Those are their submissions.
I will bang on that, my lord. There are other. The whole case has not been done properly, my lord.
Yes. Let's see the confession statement. 81.
And if you go through, my lord, the confession also, there is no memorandum of confession made by the magistrate. No memorandum also was made.
You see, Mr. Kanjing, you look at page 81. Page 81, just, you see, look at this number 3 here. What does it say? Read, what does it say?
81. Yes, having talked with the accused, explain to him each of the matter mentioned in paragraph 5. And here and there, this is all ready-made, printed. But there's nothing to show on the card.
Format, no doubt.
Format only.
But it is implied.
But-
it is implied that these the contents of this has been read over or explained to the accused person.
In my
If you see that there is,
In my respectable submission, my lord.
it has been done so, then where's the evidence that it was not done?
Because of in his deposition also, his statement is nothing but only the printed one. Otherwise, there's nothing he had written. In his statement, there's nothing. In the deposition before the court, nothing. Where he has explained?
Did they engage their own counsel or did they have legal aid
Pardon, Your Honor?
before the sessions court?
They engaged counsel.
Engage counsel.
Yes. Of course, with respect, my lord, there are many counsel also did not cross
So
many
that is
points.
what?
But that, of course, is
It doesn't come out from the deposition itself.
yes, yes.
Look at page 82, it's the same thing. Page 82.
I have some problem with reading, so I can't actually see this.
Let us go through me because, my lord, it's a fact that the PI where there was police personnel present at the time. Then it's not a fact that confession.
Mr. Kinting, sorry, we're just having some we will examine this aspect. We'll take up this matter another date when I'm.
84, Your Lordship, is the type copy of the confession
84 type
statement.
copy.
If Lordship is, please kindly come to page 84, Your Lordship.
That's why I said hasn't stabilized.
Lordship, yes.
That is the problem.
Then Lordship will kindly have page 85. All type, Your Lordship.
And this is the one I've pointed
Lordship,
to, Mr.
yes.
Kinjiri.
Because page 81, Your Lordship, these are handwritten. And page 85 onward up to 86, Your Lordship, these are typed. Up to 87, Your Lordship, these are typed.
So, Mr. Kinjing, the entire case only procedural irregularities. That's what you're saying.
Yes.
That,
And
that
now-
occasion this confession statement,
Yes,
which
sir.
you say because of that will not be admissible, and therefore.
That is what even the decision, the order of the landed, the judgment passed by the district constitution judge also.
It relied only on confession statement.
One confession statement.
We have not seen the judgment anyway.
You show me that, right? And over and above also, the most important also, my lord, the memorandum in 164, my lord, it is very clear. Any such convention shall be recorded in Mandal provided section 281 for recording so and so, and shall make a memorandum at the foot and record the following effect. I have explained that he is not bound to make confession. So there is no, this memorandum was not given there. So I beg to submit, my lord, how can you say that you have explained this just because you fill up the form? Because in the memorandum, nowhere has stated that he has done it.
Come out in evidence that all these things happen. To think to discredit the confession.
Look at page.
Your Honor,
Page 93 is the type.
it's a fact that I did not make a memorandum at the foot of the confession statement recorded, but have written RO and AC there. Read about an acknowledgement correct. How can it be like that, my lord? So how can we say that he has done according to that type form, my lord? And another thing also, that with respect, of course, to that magistrate at that time, he said that I have conversed with them in the local language, Pana language, which I am very well versed. The person who recorded this confession, my lord, is not a Panar, he is a Khasi. So he said that it is a fact that I have conversed with them in the local language, Panar language, which I am well versed. The fact that I urgently belong to the Khasi community, so my lord. How can we say that they understand? These are from North Yang. They are not even from Jiwai also.
Who says that you can't understand? It's so akin, you can understand.
No, that's why I say right from the beginning, it's not that it is a case of illiterate people of North Yang, my lord.
Anyway, it is.
But anyway,
so that is, in some substance, that is your submission. That only that there was the total disregard of procedure. They were not explained properly. They made the statements. It's been used against them, and the entire conviction is based on confessional statements. What about the deposition and during the trial?
Deposition. Jangan ni. 28. 28. The deposition might not start from type 28, but the type 28 of the paper book. Page 31 is a type copy.
Okay.
I know of the case the deceased is the son of my cousin sister, Sharbi Rakai, and the house 31. And the house of deceased is in the compound as that of my house. On the day of the incident, I was at home and we are having puja in our house and it was dark at the time when the deceased came to my house and picked up quarrel in people who had come to attend puja in our house, and we are Nyamtre, that means indigenous religion. And the accused person, namely Mur Rakai, Thum Rakai, Mura Rakai, Yola Rakai, pulled out the deceased from the house. Accused Thum Rakai and Mura Rakai are the son of my elder sister, and accused Mura Rakai is my younger brother, and Yola Rakai is my son. When the accused pulled out the deceased out of the house for creating trouble during puja time, I did not go and see what happened, as I myself was preoccupied with puja ritual at that time. I do not know who killed the Salon Rakai, mother of the deceased. Then, of course, the mother of the deceased, Timothy so-and-so, has died 2 months back. That means the person who filed the FIR has died 2 months back. That means 2 months back only, because this was recorded only in the September 2014, after 2006, after eight years. So my lord, he also has stated, this witness has stated that he did not say that these people are the people who committed murder. None. And now I'll come to my lord to another witness, because this is within the family only.
Is a relative, the one who was killed?
All of them are family.
Relative.
All of them are family. Now we'll come to another page 35, my lord.
Yes.
My name is Dab Rakai. The deceased is my cousin brother, and Pilbliu is my sister. Pilbliu is my sister. The deceased and the accused, Mur Rakai, Thum Rakai, Yola Rakai, are related, as the deceased is their uncle. And the accused, they are my sister's son, and and we all stay in the same compound. On the day of the incident, we were having puja in Pilbliu house, where the deceased Salon Rakai came to the house of Pilbliu and created trouble with the people attending the puja and picked up quarrel with them. The ladies were busy with the puja preparation and ritual. The deceased was pulled out of the house, but I do not know by whom. And I do not know how the accused was killed. The mother of the accused, Charbi Rakai, is my auntie, and she has expired about 2 months back. 2 months back in her newly built house at Mukdok, Natyang. So these are the 2 witnesses only brought by the prosecution before the district judge, my lord. Before the
Only these 2?
Before the, only 2. Then, no, other witnesses are there.
Of course, I mean.
Then there are sexual witness. That is in P36, my lord. And this material exhibit also were not sent for forensic examination, my lord.
What was not sent for forensics?
Forensic
What was
examination.
not sent?
Beg pardon?
What was not sent for forensic, you said just now, sorry?
The cis item.
The seized items.
The
item.
alleged murder weapon.
Yeah, yes.
I mean,
the
they
alleged
were
murder
not
weapon.
sent for forensic. No fingerprints were taken. Nothing.
Nothing.
Okay.
Now page 38, my lord. My name is B. Palanki. My father's name so and so. This one is a police only. I joined the police service as Constable 86 and posted in July. I know of the instance case as I am directed to accompany the IO to the PO on 11/7/2006, which is the road of Natiang only. On reaching PO, we found the deceased dead, and we removed dead body to Natiang PIC. The IO, Sri Lamare, who seized from the spot, set an article. On the same day, 12:15 p.m., before removal of the dead body, all those seized articles, one big stone with blood stain in it, one hammer with small wooden handle length 2 inches, 11 number 5 firewood. These are the seized items, madam. I have also signed on the seizure list Exhibit 1 is my signature also, and Exhibit, and they are material exhibit. One big stone, Exhibit 2, hammer, so and so, and 11 number firewood. And this material exhibit were not sent for forensic examination. And the witness have given here also, my lord, but all are only a police, and there another one also. There are 2 witnesses, including there is only 1 witness, and there is no public. In spite of the fact that in the statement area I have seen somewhere else that there it is in the road in Natiang only, where there are many public, my lord. Page 39. Then another witness, my lord, the wife of the deceased. Page 39, my lord, the type copy. Right, man. I received a summons from the court. I know this case as the deceased my husband, Salong Rakat. I know the accused person, Dilip Sarmang so-and-so, Thum Rakat, so-and-so, Yorang Rakat, as they are my brother-in-law and related to deceased Salong Rakat. I remember the year of the incident which happened on 2006, my lord. The incident occurred at about 7 p.m. My husband was murdered. On the night I was at home, since I have just got baby, who was only 2 weeks old. My deceased husband, after having his dinner, went out of the house to purchase biri. At about 8 p.m., my neighbors came to call me and inform me that my husband has died as he has been assaulted by unknown people. I accordingly went out and found my husband lying dead on the road near the house. Thereafter, I went home and put my kids to bed. Later in the night, the police came and asked me for a shawl from me, and accordingly I handed over a shawl to the police, who covered the body of my deceased husband. I did not know who assaulted my deceased husband, as I did not inquire from my neighbors or my villager how my deceased husband died. So in this case, you see, my lord, it clearly shows, the statement of this Sudan case clearly shows that there are many people, she has stated by unknown people, and this happened on the road, near the compound of their house only. That's why the way it was investigated, my lord, it has done in a very, very perfunctory manner, implicating the appellant, my lord, without any material at all. No public, none of the public of Natiang has stated that these are the people who murdered her. who killed them. So, my lord, I would like to draw your lordship's attention also to the fact, my lord, that the statement of PW1 and PW2 is quite different from what the statement of the PW4. Because they didn't say anything. They say that they pull out of the house. No, they didn't say that these are the people who killed him. And this wife also didn't say that they are killed. And in this case, she didn't even inquire from the neighbors also. And within because Nartiang is not a very village people. Many people are quite civilized also, in the sense that there are many people, and there is a PIC also there, public police investigation center also is there. Then another witness, of course, my lord, is in page 40. I received a summon to depose for this court. I am serving in the police department, Government Meghalaya, since the year 91 as SI. I am promoted to the rank of inspector in the year 2007. I am presently posted reserve inspector at 1st Battalion, Maoyong. I was posted at DYPS. I know of this case as I am endorsing authority. On 11/7/2006, received FIR, which was forwarded to the in charge, Nartiang PIC. SIC Lamari for registering of the case. Accordingly, on going through the FIR case register by DYPS case number 81 within bracket 706 under section 202/34 IPC. The FIR is received so and so, and then the Lamari is interested in investigation. Exhibit 1 is a FIR, and exhibit 1 by 1 is my signature. Then what is stated in his cross? Besides what I have stated, my chief, I know nothing about the case, and I did not play any role in the investigation. So this one, of course, he did nothing, my lord. But in this case, there is no independent witness also, my lord. And as far as confession also is concerned, my lord, this confession they have denied it in their 313, my lord.
They denied the 313?
Yes.
You may have denied in 313, but that would not amount to retraction. Because retraction would come, at an earlier stage, as soon as they have given their statement. Anyway. There is speech.
Page 132, my lord, the statement of And the relevant portion, my lord, is on page 137, my lord. It also transpired from the evidence of PW7 that you keep a statement voluntarily. You confess that you, along with 3 other accused persons, pulled the deceased on the road and killed him with hammer. 137, my lord.
Paragraph
16. That is the question put by the court. He has recorded your statement in the English language, and before he asked you to put your signature, he have explained to you in plain language whatever he had recorded, and what you stated thereafter. He asked you to put your thumb impression. Exhibit 4 is so and so. Then his reply is that I did not confess to anyone, my lord. From his answer also, my lord, it can be safely said that this man does not understand what is the meaning of confession also, because it was not explained to him. What is the meaning of confession? I did not confess, he said. So how can we say that he has confessed? It's not an afterthought, my lord. Then further he says also in another question number 17 that I was falsely implicated in the instance case. I respectfully submit, my lord, that the statement of he was falsely implicated because the way he was investigated also, where is the concrete proof that these are the people who killed him? Nothing. There's nothing to show that.
Even circumstantially, he's not there. But then even the evidence also, this is your list of compilation of judgments to give in support of your case.
Yes, my lord.
Yes.
What? Anything else?
Yes, my lord. Regarding confession also. Now, my lord, regarding the timing, my lord. The timing, my lord, in which the confession was recorded is one person, Thumrakai, was recorded at 2 p.m. It is on record, page 80 to 87, my lord. 80 to 87, at 2 p.m.
Yes.
Then another appellant, my lord, Murrakai, was recorded at 2:30 p.m. at page 80 to 95, my lord.
After half an hour.
Then another, my lord, the appellant Murrakai at 3 p.m. at page 96 to 96 to 103. Then the appellant Yolan Rakai at 3:30 p.m. at page 104 to 111. There is no break and no time for reflection was given to the appellant during confessional statement of 2 hours. That is in page 42, my lord.
You were already given time for reflection before that.
Yes, before that. Reflection before that.
The recording of the confession was done serially.
I respectfully submission. So long he has not been recorded. Then when you start right from that time you were sent back there. They cannot be summed up like that, my lord.
The defense also not lacking so much.
Penyidik itu Sarban. Page kan? Page Sarban. Page. Hah? For this, my lord, I rely also on Supreme Court decision, my lord, in the case of Sarwan Singh versus State of Punjab. As reported in the...
Which one, Mr. Kinjin?
Sarwan, page 45, my lord.
For your compilation?
Yes, my lord. 45. Sarwan Singh.
Sarwan Singh, Sir Punjab?
Yes, my lord. When an accused person is produced before the magistrate by the investigation officer, it is of utmost important that the mind of the accused person should be completely free from any possible influence of the police and must be sent to jail custody and be given adequate time to consider whether it should make a confession at all. Ordinarily, it should be given at least 24 hours to decide, my lord. This at no point of time they have done it, 24 hours.
Where did he go?
That in page 953, when an accused person is produced before a magistrate by the IO, it is of utmost important that the mind of the accused should be completely free from any possible influence of the police and must be sent.
See, ordinary means 24 hours ordinarily should be given. But then this time he's given, he was not sent at all. There's a question of now the varying time, whether that is anywhere, where do you say only for 2 hours? How do you say that only 2 hours they were sent for reflection? Has that come out anywhere in the...
In page 42, my lord, of the statement of that magistrate, my lord, on 13/7/2006,
now, Mr. Kejri will PI room. Mr. Shala was sending to PI room amount to, no, what I'm saying is that the accused should not be sent for reflection into, to a threat of being going back to police custody. Whether what Mr. Kenjing is saying is that the fact that they went back, they were sent to the PIM for reflection, that means that, they were under sort of some kind of...
Lordship,
my lord, in the
judicial lockup, your lordship. Lordship kindly appreciate these are pre-separation, your lordship, trial. Lordship will kindly recall that even in DC office, when the CGM court, Lordship Magistrate Court, your Lordship, they will produce the accused for recording. They will be set in DC office, your Lordship. So in the ground floor, there is a judicial lockup, your Lordship. I know now it's still there or not. I don't know. It is a judicial lockup. It is not a police a police room, no, your Lordship. It's a judicial lockup.
Recorded by the magistrate himself, he said he sent him to the PI room along with the attached peon.
PI room, your Lordship, that means a judicial lockup is attached to the PI's room, your Lordship.
Oh, my lord. He was sent there and...
Lordship will kindly recall...
let me reply for that.
He was sitting there. They were sitting there and then...
and in the PI room, I'll tell your Lordship, everybody know, all serious counsel who are used to practice, we know very well, that in the PI room, there are so many police who come. The IOs used to be there only, sitting with the
So you feel that because of this, they were intimidated and
certainly,
when there was no time for reflection,
certainly.
So they went back and said that they did it.
Because there is
Where
no...
were they supposed to be sent for reflection then? Is there any specified location where they are to be sent?
Of course, that is not arrest for policemen. It's not my.
And regarding time also, Mr. I don't think it's hard and fast rule that you send reflection 24 hours. It's not a hard and fast rule. Ordinarily, you send given adequate time, but 2 hours will be adequate for the reflection.
But the fact remains, my lord, that in the police room, in the PI room is nothing but a police room only, and then there are many IO of all the district. That is a well-known fact for all those serious counsel who use practice in the district court. There are many IO and sub-IO and below IO also there. And not less than 4 or 5 are there in that room.
Mr. Kinji, even if Again,
That's come from nowhere.
I'm repeating myself. Even if that argument is taken,
Where?
where is
Where is
there
it?
specified that they have to be taken? Somewhere to a hotel, somewhere to the hospital or something like that. Where is it written?
Of course, that is for the administration on this stage.
We'll continue tomorrow. Only one thing is that you come up with some authorities with regard to that point which you feel maybe, because the entire case is hinged only on a confession statement. So you have to be overwhelming arguments you have to make to show that it is that the whole, if you say the whole conviction is based on confession statement, that means that it should be disregarded on what manner, whether, how much can you outweigh the acceptance and the position that they've given, the statement they've given here. I think we'll examine the judgment of the Section Court also. You understood the trend and what your case is.
Not tomorrow, Krishna. Not tomorrow.
This is after 1 week for the hearing. Then next week we'll finish it, Mr. Kulai.
Let be after 2 days, my lord.
Release it after 1 week.
After 1 week, because we have slight difficulties there.
Keep for this discussion.
Yes.
Right now we are talking like that. We are going to be
Only the time taken to finish one trial is alarming. If
Lordship, this is a pre-separation trial.
If the charges were only in
the Lordship, yes.
in 2000 and after 8 years.
Your Lordship, I'm thankful to him also, yes, Dr. Leonard Appeal Counsel, my friend. Because why? Because this magistrate recorded confession also is not from judicial side. He doesn't understand fully what he has done.
But that we suffered that for how many years, Mr. Kenjing, you know very well. You are Advocate General also.
Even then, when
so that is one
anyway,
thing which our courts out here we have to deal with. We are alive to that situation that there are many limitations, especially in the.
But the fact remains, my lord, that this appellant, they are
illiterate.
They have been convicted for life. So at least all avenues should be.
Of course, it's not a question that they're just being summarily tried or or your appeal just be thrown. No, we'll examine everything.
Regarding that confession, Your Lordship, in 313 statement, Your Lordship, which my learned senior friend has skipped, question 13 is very specific, Your Lordship. They have admitted, yes, it is a fact.
We'll look into that.
Lordship, yes. That I'll point out.
Yes. Yeah. What's the written?
Supplementary list. Item number 1.
The petitioner challenges Annexure P5.
Yes.
Annexure P5.
Annexure?
P5, page number 55.
What is this?
It's a Rajasthan University Repealing Act. Actually, Annexure P1 Repealing Act, the P1 statute. P1 is the Rajasthan University Act that was passed on 4/2/2020. Even though it is the Act of 2011, notification was passed only on 4/2/2020, and subsequently an amendment was carried out as per Annexure P2, page number 41, on 4/2/2020. So
Page
the
number?
Act came into page number 41, P2.
41.
P2, page number 41.
Okay. Yes.
By way of amendment, the governor was appointed as the visitor of the university.
Yes.
Only that was the sole amendment. So from 4th February 2020, this act came into force from 4th February 2020. So subsequently, in March 2020, all of us know COVID broke out.
Yes.
So the entire thing paralyzed. In March 2020. Subsequently, the chairman of the trust, he's the second petitioner, one Mr. Dr. Rajit Lal. He underwent liver transplant surgery in Chennai Hospital, exhibit P3, and Annexure P3, page number 42. So, subsequently, on 22/9/2023, abruptly, the Meghalaya Legislative Assembly passed Annexure P5 Repealing Act. Subsequently, without giving us any notice, without issuing any notice or anything like that. Lordship may kindly consider 3 aspects. Because this Annexure P1 is a self-contained act in which there are certain parameters, guidelines to be followed before dissolving the university. I am referring to page number 39, my lord. Page number 39. P1, page number 39.
39.
Page number 39. Annexure P1 page Act, page number 39.
Yes, okay.
Dissolution of university, section 48.
If the sponsor, yes.
Yes,
Read,
if the sponsor proposes a dissolution of the university in accordance with the law governing its constitution or incorporation, it shall give at least 3 months' notice in writing to the state government. 2. On identification of mismanagement, maladministration, indiscipline, failure in the accomplishment of the objectives of the university, and economic hardships in the management systems of the university, the state government would issue directions to the management system of the university. If the directions are not followed within such time as may be prescribed, the right to take decision for winding up the university would vest in the state government. The manner of winding up of university would be such as be prescribed by the state government in its behalf, provided that no such action will be initiated without affording a reasonable opportunity to show cause to the sponsor. Here, no notice was issued regarding the dissolution of the university. No opportunity was given to the sponsor.
Where's the impugn order? Impugn act, let's see. Where's the impugn? P5, we said.
P5 is the repealing statute, my lord.
Statute, yes,
It's a repealing statute.
Yes.
So without issuing us any notice, or without issuing as an opportunity for hearing, abruptly passed a repealing order. Exhibit P5 repealing act was passed abruptly without any notice or without affording us any opportunity to say why you are not started the university. Actually, the university, there are other procedure also. I am referring to section 51, my lord. Roshma can refer to 51. Section 51, page number 40. Section 51, may read section 51. Page number 40, if any difficulty arises in giving effect to the provisions of this Act, the state government may, by a notification or order, make such provisions not inconsistent with the provisions of this Act, as appeared to make such provisions of this Act as appeared it to be.
We just go to statements, objects and reasons for repealing. Anyway, you take notice.
May it please your Lordship.
So, Lordship, kindly pass an order staying the operation. I am strongly pressing for it.
There's no, you never stay any statute.
Yes, well.
Unless it's...
Lordship, will kindly, if Lordship kindly see that education falls under list 3, Your Lordship, at item 25 of the concurrent list, Your Lordship. If the state legislature has the legislative competence to enact a law, Your Lordship, that power of the legislature of
you
the
file
state
affidavit, you file it. You are Mr.
is co-extensive, Your Lordship.
S.P. Rajan.
S.V. Rajan.
S.V. Rajan. Heard Mr. S.V. Rajan, learned counsel with Krishna with so-and-so. Issue notice. Mr. N.D. Shulai, learned EAG with so-and-so is present on behalf of the respondents, so no further notice called for. This is matter after 4 weeks.
Lordship.
Yes, sir. Affidavit we file before the next date. List on so-and-so. You take a date for convenience.
Daily list item number 1.
May please, Lordship. Lordship, we have received the copy of the affidavits. In fact, my lord, the works, the repairing works, they have been carrying out. They have carried out the works and still under process, my lord. And in fact, as per my instructions, the Joy bypass, my lord, the starting point and the end point, my lord, they have done it. But in the middle portion, there are, my lord, the portals left. So probably, my lord, it will be done. And as per the affidavit filed by the, my lord, NHI, they said, my lord, till 25th. So, my lord, it can come after that. So that, my lord.
Okay, we listed Mr. Panthi submits that the affidavit, they have received copy of the affidavit and on independent survey, I have noticed that certain repairs are being taken out. So, he placed the matter we listed after 3 weeks.
After 3 weeks, my lord.
After 3 weeks.
Lordship, on 16/11, the Deputy Commissioner has submitted the report.
So, before the Commissioner submitted 16/11.
There are other aspects also, my lord. If required,
you come
we'll
with that,
point
you
out.
see first
Yes,
whether
my
it's
lord.
done or not. Yes.
We'll do that, my lord. Oblige, my
Number
lord.
2.
My lord, this is a matter we have. The respondent was transferred, my lord, from Shillong to Tura, my lord, Post Office, my lord, and he challenged before the CAT. CAT is to interfere with the transfer order, my lord. Against that, we have come before this honourable court. Before this honourable court, a submission was made by the respondent as his salaries has not been paid for past few months, my lord.
Where's the respondent today?
My lord.
Yes, Mr. Nath.
My lord, I am appearing for the respondent, my lord.
Yes.
My lord, my lord, it was a detail heard by the Chief Justice on 20th of September 2023, and the repetition was about to be dismissed.
Please listen, please
My
listen.
lord.
What was heard, matter bench,
lord.
this bench not aware. See, you don't have
My
any,
lord.
what do you call it, ESP or something, extra sensitive perception of what other bench has heard and whether we will, you know.
No, my
The
lord,
only
order
question
has
is,
been
please
passed.
listen. And at least focus on
My
your
lord,
face,
kind.
firstly. Can you
lord.
make a camera, adjust your camera that we can see, yes, the counsel, yes. Very good. Not sideways,
Yes, my lord.
yes. Right,
My
very good.
My
Have you seen your salary or not?
No, my lord,
My lord,
salary,
I am not getting myself.
Yes.
my lord, salary has not been paid, my lord.
Why?
My lord, I have instruction. There are two aspects of the matter, my lord. He has not joined duty since then, my lord, and there are no leaves dues to him, my lord. So,
What about the order which says that in the interim that whatever dues permissible, all dues respondent should be paid, whether or not
No
these dues are
interim order,
resolved, and not standing penalty will matter.
my lord, my instruction is that, my lord. Second aspect, my lord, this is here he was transferred on account of very long delay in processing the parcels, my lord. He was in charge of parcel section in the GPU, my lord. And over a period of time, there was a fall in delivery timeline, my lord. And because of that, action was taken against him and he was transferred, my lord. My lord, another aspect is that he is being proceeded against for defalcation of 32 lakh rupees, my lord, in another proceedings. The same respondent, my lord. And against that, departmental proceedings were initiated against him, my lord. 20,000 per month for 13 years was to be recovered from him, my lord. And somehow the matter is, he filed a departmental appeal, my lord, and the matter has been directed to be proceeded de novo, my lord, from the stage of charge sheet, my lord. So that is still pending, my lord. In the given, because on the last occasion I made a submission before this the Honorable Court, my lord, that I'll try to persuade the department to accommodate him somewhere else, my lord, instead of sending him to Tura, my lord. My lord, the difficulty department is facing, my lord, only there are few offices, my lord, where the post office employee doesn't have to deal with money, my lord. So that's why he was kept in parcel section, my lord, where he does, if he is posted to any other branch, my lord, because this is a single employee post office mostly, my lord, where apart from dealing with postal matter, he is to deal with finance also, deposits, and he is found embezzling 32 lakh rupees of depositors' money.
Okay, has that come out anywhere in the judgment?
My lord, these were not the part of.
Then?
So, my lord,
can we take that consideration or decide this matter?
My lord, what I am praying, my lord, your lordship permit me to file an affidavit to bring this aspect on record, my lord. Of course, my lord, on my submission, my lord, if I can place the department upon my persistence, my lord, that you department has agreed to accommodate him somewhere near Shillong, my lord, instead of sending Tura. But in the given scenario, my lord, where he is placed, my lord, that may not be proper also, my lord, to give him a favorable on my intervention, my lord.
Yes.
May I submit, my lord?
1 second.
May I submit?
Lord, may place the instructions, my lord, the written instructions I have.
So, see, Mr. Dr. Mozika, stay was refused by this bench, correct?
Stay was refused. But stay was refused, my lord. These two aspects were not brought before this honorable court. This I didn't know also, my lord, that he is found guilty of.
Then we have to make a fresh prayer then.
For recalling the interim order, my lord. For the interim order, my lord.
Yes. If you feel that there are certain facts which have come to
order was only to the effect that, my lord.
May I submit, my lord? May I submit?
Yes.
All the dues of the respondent, my lord. Our case is that he does not have any due, my lord.
Yes, Mr. Narbil. Don't worry. Yes, 1 second. Just let us see. Yes. Yes.
May I submit? My lord, the transfer order was issued with a malified exercise of the administrative power. The tribunal in details heard the matter, relied on the judgment of the Honorable Supreme Court in the case of S.L. Abbas, and relied on the also judgment of the Sumesh Tiwari versus Union of India. The Supreme Court judgments are referred. The fact behind the transfer is, my lord, the friend is not presenting the fact behind the transfer. Why the transfer was issued? The applicant joined at the disposal center on 1st of July of 2022, and he found that lots of the matters, the undelivered parcels are pending. So he lost they asked the postman, 3 postmen, that you carry this. They refused to carry. They said that only 50%.
Okay,
we
understand.
So
no. The thing is that, see, as the matter stands today, now the CAT came to a reason finding that you unfairly treated, that he was unfairly treated, right? And so they interfered. Now you have come before this court by writ petition. You've asked for interim stay of the order. That has been refused. So that we are there. Now you're trying to bring in new facts to show the that why the action was occasioned by the respondents, and placing him in Tura. So that's where we stand now. Now that's one aspect. Another aspect is, from what can gather, is that are there any dues pending against him or not?
My lord, there are no dues.
There are no dues.
Because he's not.
That's where because
he's not coming to work,
with that. Mr. Nath, are there any dues that he's supposed to get?
My lord, he was not being allowed because the tribunal has passed the judgment on May 2020.
Any dues payable to him as on today from the department? For which has been
yes, my lord, salary since 2000 February he is not getting salary.
Since?
2000 February 2023 is not getting his salary.
Is that correct?
My lord, entire family is under my lord,
salary?
My lord, he has not joined his work, my lord, and there are no
My lord,
leaves.
they are not allowed to join. How I will join? They are not allowing to join. How I will join, my lord?
How can we discern
They are
that?
not allowed.
We can't come to any conclusion finding about that. Whether, what is this?
My lord, on last occasion, I placed before your lordship, my lord, that I'll try to intervene, my lord. Though on my intervention, my lord, the department has agreed to accommodate him somewhere near Shillong, my lord.
Who is the local council, Mr. Nath?
My lord, Mr. Mike is a PI local council.
Now, what is he doing sitting behind? Give a copy of this communication to him. Mr. Nath, they have given one letter, 1811. With respect, they have directed us to request you inform, will be accommodated post in around Shillong. You take this instruction, the instructions from your client. We listen after one.
My lord, the first.
Meanwhile, if there is dues, you kindly release it.
My lord, the first letter is on my insistence, my lord. But when on Friday I insisted, my lord, on the department, I prevailed upon them, my lord, that please accommodate him. But when the other material came to light, my lord, that he is also guilty of embezzlement of fund, my lord, and he has not joined duty, my lord, and he's making a submission before this honourable court that
of these things, right from the single bed records, these are not there, Dr. Mujiga. It is not there. And see the last order of the court. It has expressly said that you should pay all those dues.
Dues, my lord.
Then we are bound by this order so long this order remains.
My lord, dues.
We cannot make any submission.
My lord, our cases there are no dues, my lord. Because he has not reported to duty for many months, my lord. That is the second page will indicate, my lord. The second page of the instructions, my lord. And there are no leaves available to him, my lord. He has exhausted all his leaves. So if he is not coming to work, my lord, he will not be entitled to.
Pursuant to order dated, pursuant to order dated 12/10/2023, when the matter came out on 16/11/2023, difficulties expressed by the learned DJSG to comply with the order dated 12/10 as he was without instructions. Stop. Today, the stated submission, the stated position is that, as per the learned DSG, is that there are no dues outstanding as regards the respondent, in as much as he has not.
He is not coming to work, my lord.
Whereas Mr. S. not appearing on behalf of the respondent, respondent submits that he has been prevented from doing so. Stop. Further, a communication dated 18/11/2023 has been placed for this court with regard to the posting of the respondent in and around Shillong, which, however, also is sought to be retracted by the learned DSG on certain other grounds which are not present in the proceeding before CAT or before this court. Stop that view of the matter. You file affidavit in 1 week. Let an affidavit be filed by the petitioner union within 1 week. Yes. Less on so. We'll put an affidavit, your objections, then we will deal with it.
My lord, may I give the date, my lord?
Yes, you take a date.
Hearing?
On 29th of my lord, 29th of this month.
29.
Oblige me, deeply obliged.
Finished.
Made with your similar.
Yes, Dr. Saraf.
Well, these matters were earlier adjourned on the ground that the matter was pending before the Supreme Court.
Yes.
Similar matter. Now the Supreme Court has decided the issue. Yes. Well, the issue is that the industry were entitled to excise exemption as per the industrial policy of 2007 and the notification issued consequently. Now, certain education cess has also to be paid, and that were not refunded. Now, the issue was that whether education cess will also be refunded, exempted when the excise duty is exempted. Now, that issue was pending and the amount was not paid. Ultimately, the Supreme Court, in SRD Electrical's judgment, held that the education cess will also be exempted. Accordingly, some writ petitions were filed before this honorable court in some other matters, whereby this honorable court directed the amount to be refunded on the basis of the Supreme Court decisions. Accordingly, the amounts were refunded to the petitioners. Now, after refund of the amount, after a lapse of some months or so, the Supreme Court in subsequent judgment, my lord, held the earlier judgment to be, my lord, per incurium, the SRD electricals. Now, after the declaration of the judgment of the Supreme Court to be per incurium, my lord, the notice was issued for so-called demand notices for recovery of the amount which has already been paid. Now, the petitioner challenged before this Honorable Court the source notices on the ground, my lord, that even if the judgment of the Supreme Court, earlier judgment has been declared to be per incurium, but the matter which has attained finality cannot be reopened on the basis of the subsequent law laid down by the apex court. Now, this issue, in fact, I placed before this Honorable Court two judgments, my lord, of one of the Guwahati High Court as well as one of Tripura High Court on the same issue, whereby, my lord, the same view was taken and the impugn notices were quashed. But since a prayer was made before this Honorable Court that the matter is pending before the Supreme Court, this Honorable Court thought it fit, my lord, to adjourn the matter till the matter is decided by the apex court. Now the apex court had decided the issue, my lord. I have given a copy of the judgment.
What does it say? Yes.
Well, it said that the earlier amount cannot be recovered. Whatever has been refunded, that cannot be recovered. That is, my lord, Commissioner of CGST versus Saraswati Agrochemicals, my lord.
So what do you do with your writ petitions today? We close them?
Well, it can dispose of on the terms of the judgment of the Supreme Court and the impugn notices may be quashed. You'll also kindly see, my lord, paragraph page 5, my lord.
Yes, I was.
The contention of the revenue, my lord. The bottom the page number is there.
Yes.
May I read, my lord?
Yes.
The contention of the revenue is that in view of the subsequent judgment of this court in unicorn so-and-so, recoveries could be made from the SSCs with regard to the refund of expenses made by the department or if not paid by the SSC following the judgment in SRD Electricals Limited. In the above circumstances, appeals were filed before the High Court by the SSCs. To the extent the High Court has raised the following question of law and answered it against the revenue, whether the SSC is liable to return the expenses and secondary and higher expenses on the changed view of the law as subsequently laid down by the full bench of the apex Supreme Court in Unicorn Industries versus Union of India, reported in so-and-so. In our view, the High Court has rightly answered the aforesaid question. The High Court in the impugned order, while considering the judgment passed by this court in SRD Electricals as well as the Unicorn Industries, has observed as under. My lord, I will skip over the next page, my lord. In substance, the High Court has stated that the decision in SRD Electricals had attained finality and was binding on the parties thereto. Therefore, the subsequent decision of this court overruling the SRD Electricals in case of so-and-so had not have a bearing on the past decisions which had attained finality, although they had followed SRD Electricals Supra, which was subsequently overruled in so-and-so. Otherwise, a Pandora box would be opened and there would be no end to the litigation.
So, Dr. Sarah, we are saying that the later judgment whereby the SRE nutrients were overruled is a prospective declaration of law. Will not apply retrospectively.
But which will not apply to the transactions.
No, I mean, it simply is that it's a prospective declaration of law which came by the second judgment. And so, prospectively, it cannot, I mean, retrospectively, it cannot apply because it attained finality in the last occasion. Is that your submission?
My lord, this is the submission, my lord, that the funds which were already granted on the basis of the earlier judgment of the Supreme Court, they cannot be. Because, my lord, this is the same judgment. Oh, I'm sorry.
Yes, Dr. Modika.
My lord, here what happened?
The same question, my lord, which has been raised before the
we have heard you. Yes.
My lord, the question was whether when excise duty is exempted under the Northeastern policy, my lord, so education cess is paid as a percentage of excise duty, my lord. For example, 100 rupees transaction, my lord. For example, excise duty comes to 10 rupees. Education cess is calculated 2% of 10 rupees, my lord. So the question was, when excise duty is exempted in Northeast, my lord, whether education cess will also remain exempted or it will be payable, my lord. All these years they were paying, my lord. Now, a decision came in SRD nutrients, my lord. The Supreme Court held that since excise duty itself is exempted, the education cess will also remain exempted, my lord. Based on that decision, my lord, several writ petitions were filed before this Honorable Court, my lord, that the law has been declared otherwise by the Honorable Supreme Court. So, and because of the orders passed by this Honorable Court, we refunded the money to many of the industries, my lord. Soon thereafter, my lord, in Unicorn, which was a matter arising from Sikkim High Court, my lord, Supreme Court held that SRD nutrient was not a correct judgment, my lord. It was per inquiry. After that judgment came, my lord, we again issued so-called notice to them, my lord, that what we refunded to them earlier, please come back and repay it to us. Because now, in view of the Supreme Court ruling, you are liable to pay that. Against those notices, they have come before this Honorable Court, my lord. My lord, only one aspect.
We are bound. There's no way out. We are bound. 141,
My lord, there was only one aspect. I don't, though I need some instruction on that, my lord. My lord, what happened, my lord, when first decision was passed in SRD nutrients, my lord, some companies came before this Honorable Court, my lord, by way of writ petition, and orders were passed by this Honorable Court to refund their amount, my lord, what was paid by them as education cess. So in some cases, pursuant to the orders passed by this Honorable Court, we refunded, my lord.
If they've closed everything, you've already refunded. He said, close it. Whatever entitlements or rights you have, it's a sort of prospective declaration of law. It's over. Instead of opening Pandora's box again, where it will be endless litigation for you, serving notices again, trying to extract the education cess, which already been refund of refund. So they said close it there.
After SRD nutrients, whoever came before this Honorable Court and they've refunded, not to reopen those matters.
Well and good, those not been refunded, well and good. So that's where the position is today. If I understand correctly, I might be wrong.
Only one difference, if that is accepted, my lord. Some came before this Honorable Court, my lord, after SRD.
No, what position can we are bound, Dr. Mozika?
No, my lord, a slight distinguishing point can be there, my lord. Some companies came before this Honorable Court following SRD nutrients, my lord. And because there was a flurry of cases, my lord, some of them without even coming before this Honorable Court, my lord, the departmental at their own, they process their refund, my lord. Because saying that we are bound by SRD nutrients.
So how does it have an effect in this case? What effect will it have if a departmentally on its own, party is not before this court, they refunded? So what kind of impact will it have on, on disposing these matters before this court? Nothing.
My lord, what Supreme Court says, my lord.
What do you want some time to take instructions?
Lords give me 3 days time, my lord.
3 days time.
Otherwise we are bound, my lord. I'll just have instruction if
there's though the matter seems to have been settled, I mean, it's a settled position of law has emerged. Inasmuch as the order of the Novel Supreme Court operates as a prospective declaration of law, which will have no effect which have no further effect or need further adjudication, stop. Dr. M. Mozika seeks 3 days time to receive instructions. Open this is a matter on Thursday. Thursday is?
Holiday, 23rd.
Then list on?
My lord, Thursday I have some difficulty. Either Wednesday or Monday, my lord. Wednesday I can come back.
Day after tomorrow.
Yeah.
Day after tomorrow, Saraf. Nothing is there. Day after tomorrow, he wants. Day after tomorrow. Day after tomorrow.
My lord.
Yeah.
Item number 4.
The 37 batch of 37 matters.
Ashok, I'm praying for some accommodation on behalf of Mr. Chanda.
Yes?
He's indisposed, Lordship.
Who's indisposed?
Mr. Chanda, Lordship.
Oh, it's there, number 4.
Lordship.
Okay. Since accommodation is sought due to the illness of the Avin Council, this is matter after 2 weeks.
Sure, after 4 weeks.
After 4 weeks. Yes, on so.
I'm obliged, Lordship.
Yes. That's it immediately.
Any mention?
Yes.
I like to mention this is analogous matters, item 43 onwards. If it could be taken on any other date.
What are these 43 onwards?
My lord, this is that matter relating to Fifth Pay Commission.
Oh, Fifth Pay Commission.
Fifth Pay Commission, my lord.
Okay, 43.
My lord has already heard this matter.
They've taken time thereafter, on several occasions, just some instructions.
My lord, otherwise these...
We'll have it after 1 week.
Lord.
I hope the eyesight gets better. Yes.
First week of December.
First week of December, yes.
First week,
Yes.
That will be item 43 till the end, my lord.
Okay, 43 to?
Till 57, my lord.
Okay, yes.
Oblige.
May we please, Your Lordship? Your Lordship, I beg to make a mention for item number 26. I'm appearing for respondent number 6 and 7, Your Lordship.
26.
On behalf of Senior Counsel Biswajit Deb.
Senior Counsel, Mr.
Biswajit Deb, Your Lordship. Item number 26.
Who is the Biswajit Deb?
Your Lordship, he's a counsel from. He was the former AG of Mizoram.
26.
Item number 20 of the daily causes, Your Lordship.
But it's not in the list of parties here. Of lawyer counsels appearing.
No, I'm appearing for respondent number 6 and 7, Your Lordship.
Okay. Yes, who's the petitioner?
What a petition.
Yes.
My lord, actually in this matter, there's going to be a wakalatnama filed by the private respondent.
Yes.
They have informed.
Slowly.
Yes,
Yes.
my lord,
What do you want to say?
Yes, my lord. In this matter, my lord, there's a private respondent. That is a city college. Respondent number 7. They would be appearing today, my lord, to file the
I am appearing
wakalatnama.
on behalf of the respondent number 7, my lord.
Your name?
Yes, my lord.
Your name?
Shunit Kumar Roy. My lord, I have already filed my wakalatnama today, my lord.
Affidavit?
My lord, if your lordship so directs, my lord, we shall file my affidavit.
But I hope I can find.
The main answering respondent is the, my lord, the state of West Bengal, my lord.
Respondent number 6, Your Lordship.
Who's the parent for number 6?
I'm Senior Counsel Biswajit Deb, Your Lordship.
You're appearing for, they are appearing for 6, okay. So first time you're appearing, 6 and 7. Yes.
May it please your lordship, I'm appearing on behalf of respondent number 4 and 5.
Yes. No, your presence is already recorded. Only that today, Mr. Emlingdo, right?
Yes, Your Lordship.
On behalf has entered appearance on behalf of respondent number 6 and Mr. TK
Shunit Kumar Roy.
SK Roy on behalf of number 7. So as such, the service, so with appearance of all the parties is complete. Stop. You want to file affidavit? No.
I know, we will be filing, Your Lordship. We have received notice also. So, Your Lordship, as per
We
instructions.
pray for and allowed 3 weeks time to file affidavit.
Lordship,
Just
after
thereafter.
the vacations, if we can.
Yes.
After the vacations, if Your Lordship permits.
Just thereafter. Can't give it 3 weeks. Yes. After 3 weeks, take a date.
Kindly fix a date for
Yes,
hearing,
they'll give a date. The court master will fix the date. Yes.
because we have to come from
Yes.
Kolkata.
We don't treat outstation councils differently. We treat the local councils. If you're not here on that day, we'll take it up also. Yes.
What's obliged, my lord?
Yes.
Lordship, I will like to mention item number 27, Lordship. Allow me just 2 weeks' time, Lordship.
Why you're backtracking now?
No, Lordship. There are some queries that I have to ask from the petitioner, Lordship.
On request of so and so. Yes. Yes.
Obliged, Your Lordship. Obliged, Lordship.
It is Your Lordship. Your Lordship, I beg to mention item number 23, Your Lordship. I pray that the matter may come up after 2 weeks, Your Lordship.
23 after?
2 weeks, Your Lordship.
No, yes, 2 weeks. Yes.
What's your lordship?
Yes, make it quick.
Mention item 19,
Mr. Ganguly, he'll have complaints.
Yeah, Mr. Nandi is not there today,
Ganguly or Nandi?
Oh, sorry, it's Ganguly.
You don't even know who's appearing anymore. After 1 week, yes. This is 18 matter, yes.
May I please, Your Lordship? I beg to mention item 20.
20. We have other side. Colney.
Yes.
I'm praying that this matter may come after 2 weeks.
No objection.
Yes. Yes.
Supplementary list. Sorry, main list, item number 1.
My lord, this is a contempt. This is a contempt petition, my lord.
Contempt which order? Which order?
Order is, my lord, there is 2 orders in this case, my lord. One is, on the last occasion, my lord has passed the order 12/4/2023. That is at page number 17, my lord.
It was a contempt.
Yes, and the earlier order is at page number 15, my lord. 15 and 16. This order is yet to be complied, my lord, even after lapse of 7 months, my lord. I just
7 months, but this was passed in 22/10/21. Anyway, Sinkan issue notice of returnable in 2 weeks. Steps were taken by Rachel AD within 3 days. This accordingly also.
Second also similar, same.
Item number 3.
Your Lordship, if this matter can come up after some time, Your Lordship, Mr. Andy Shula is on legs and he'd like to...
What's the matter about?
See, this is a contractual teacher appointed in the year 2010 and 11. Lastly, the Honorable Court has passed an order allowing us to file a representation before the directors. And we filed representations, and the representation was disposed of by the directors.
Where the disposal?
Is a page, it starts from page 54, 55, and because the court in the earlier judgment, while allowing us to file a representation, court asked that what was the reason for not acting on the order dated 2017. That was not answered by the for 2.
Nobody a tainted teacher. You don't dispute.
No, they said I am a tainted teacher. I am not entitled as per the judgment and order passed by the court on 17. 2/11/2017. But in the order passed by the Honorable Court has asked however, the petitioner was allowed to continue service even after the judgment and order dated 2/11/2017. This court deemed fit that he may be allowed to file a representation. So that was not answered. Why I was continued till 2043.
When he made a mistake, that's all. Any instructions on this one?
Your Lordship, Mr. Shula would like to argue the matter, Your Lordship, for disposal.
Today itself.
Yes, Your Lordship.
Disposal will not be possible.
Behind, yes, Mr. Shulai.
This is Your Lordship.
Yes.
Lordship, can you come to page 54, Your Lordship? That is the order. Lordship, this is a well-written order, Your Lordship.
That's why it's challenging it.
Lordship, yes. He's a tainted, Your Lordship.
Because my appointment was different. It has got nothing to do with the teacher tainted declared by the High Court.
But that order will mean any teacher, any kind of employment.
That's what that's
the regular employment.
My appointment was on the contractual basis in the year 2010, and it has got nothing to do with the finding of the Honorable High Court. So I am. Lordship, in this case,
Lordship, he took part in the selection process, Your Lordship, and there was a direction passed by this Honorable Court, Your Lordship, for a CBI inquiry. And the CBI in the CBI inquiry, Your Lordship, he was found to be tainted, Your Lordship.
Lordship, pursuant to the order passed, pursuant to the selection process, I was not appointed. I'm not remotely connected with the selection process.
No. The thing is that where you part, selection process, you're not selected by that controversial. Selection process, correct? You were not selected at all.
No, I was selected, but I was not appointed.
Oh, because you were tainted.
I was not appointed.
Then that's a different footage.
That's what.
So, Lordship, kindly come to 1A at page 54, Your Lordship.
Yes.
54, Lordship, 54, Lordship, paragraph 1A. Lordship is with me. May I read it, Your Lordship?
Yes.
Both the petitioners were candidate of the selection process under the advertisement dated so and so and and was issued by the Deputy Inspector of School in pursuant to notification dated so and was declared selected for appointment to the post of assistant teacher in government lower primary school. However, they could not be accommodated for appointment due to non-availability of...
So then there your right goes, Mr.
No, Lordship, this is correct. But no, Lordship, that is correct. In this case, no, there is two aspects.
This is a third round
two aspects. Correct. Lordship, two aspects is there. Lordship, one more aspect is there. Lordship, I may be allowed to say. Para 25. Para 25. If I am a tented teacher, they said I am a tented teacher, my service is terminated. What about the teachers in 25? Dadangiri and the Tura, these are the tented teachers. Why they are allowed to continue? They are allowed to continue in the post.
You can't plead negative equality.
No, but why I am targeted selectively?
You can't plead negative equality.
No, because they are allowed. They are allowed to continue.
You can't plead negative equality. Then you make a complaint against these people.
No, we have. Not even the representation we have written. In the representation, what we have submitted.
You can't plead negative equality. That's all.
No, Lordship, the representation we have submitted before the directors.
You cannot plead negative equality. That's it.
No, we have highlighted. If I am appointed in 2010, then I came to the High Court. My service was allowed to continue. Yes. Then again.
Only one petitioner here.
No, there's two petitioners. At least they must give reply. They should
category, Your Lordship.
And the interpretation is required. The orders dated 17.
We filed one writ petition or two writ petitions?
One writ petitions.
You paid court fees?
Court fees, yes, we have paid.
For two people?
Two people.
Where is that?
It is there, Lordship. We have paid wakalat number 15 rupees each. Affidavit 10 rupees we have paid.
They will dispose it off. Nothing remains.
Lordship, some reply they need to give.
What reply?
That interpretation is required.
That representation.
Lordship,
reply to representation.
Lordship, the Lordship has
reply
correctly
the court sought last time. They've replied.
No, Lordship has correctly said in Lordship judgment. They said, however, as the petitioner in page 36. However, as the petitioner was allowed to continue his service even after judgment dated 2/11/2017, this court deemed it fit that he was allowed to file a representation. On this ground, we are allowed to file a representation.
Exactly.
And he has not given any reasons why I was
given.
allowed.
You were tainted, you were selected at a point of time.
But he's
a shortage of posts of Assamese teacher, you were accommodated contractually. Suppose, if the post arose, you would have been accommodated.
But no findings on that. No findings at all on that. No findings on that, Lordship.
Sorry. You withdraw or will dismiss?
Lordship, there are two aspects. Because I feel there is a discrimination, arbitrary action on the part of the department. When they allowing the same people, tented teachers...
No negative equality.
And I filed my representation also before.
No negative equality. I'll keep on repeating. That's all. No, you can't say the other people allowed. Two rights will make a wrong.
No, but the finding
two
is...
wrongs will make a right, sorry.
But how this judgment of the 17 to 12/2/2007 will be applicable?
It will be applicable.
That is required to be examined, Lordship. At least.
Have you made a pointed objection against observation in your petition? That you're not tainted and that the finding is wrong. Did you represent against the finding?
No, we are saying that we are not appointed pursuant to this selection
process. Did you make any representation against the finding as allowed by the division bench? We are aware of the orders. Did you make representation?
No, I lost my representation is there.
No, against being declared tainted before the chief secretary in the select committee. Did you make?
No, that was not made. Perhaps.
Then you have already waived your right.
Lordship, but something is to be examined, Lordship, in this case.
Nothing to be examined.
At least the government should give reply at least to on this aspect only.
Heard. We'll dispose of. Yes. Next case.
Apply, Lord.
Item number 4.
Yes. We'll pass orders. Yes. What is this, Mr.
May please, Lordship. This is actually these all the petitioners. They were appointed as a free primary teachers, Your Lordship. They were appointed by the Deputy Inspector of School and also by the assistant to the administrator, Your Lordship. Assistant to the administration primary school, GADC. This, Your Lordship, this school was actually, Your Lordship was aware that this run by the GHDC, Government Ministry Council. Later, Your Lordship, the act was passed. That was the Meghalaya taking over of
primary
Council
education
Lordship
by the
Lordship.
state. Yes. What happened?
That now this my contention here is there is a provision in the section 3 of the Act, and that where it says that salary and allowances, including areas thereof, of a teacher who is immediately before 28th day of December is a teacher of such school, the gratuity and pensionary benefit of DLC. Your Lordship, there are some benefits which I have mentioned in the credit list. Now my contention here, the petitioner petition is that they are the pre-primary school, and then now government is saying since this act is passed only for the lower primary school, but in the act we are saying that there is no distinction between the pre-primary school and
is there no
primary
judgment
school.
available on this point already? Yes, Senior Government Advocate. There must be a judgment already, pre-primary and primary.
There was
whether there is a distinction or not. Where's the judgment? You take it out.
Distinction
No, you take it out. There's a judgment by this court, I think. Somebody must have come. If I am not mistaken.
Earlier occasion I have filed the Lordship as in the directed to approach the authority.
So
So
what did you say?
that approaching the still petitioner in the what petition that we have filed an application regarding the with the judgment of the High Court that decision.
Where's the judgment? Where's the judgment?
It is
Have
still
you annexed it
pending.
here?
Of course I have not enclosed
Why?
here.
Produce it tomorrow.
Lordship. Judgment is there, Lordship.
As earlier matters had been dealt with by this court on the same subject matter, on the same subject, Mr. P.T. Sama prays he will have to bring the early orders past.
Lordship.
You just showed the, I think this matter. I don't
Yes,
know
in the case of Anjali's, if I Lordship, I will produce tomorrow that order.
Lordship.
Is it staff or pre-primary in the other case?
Same nature, because pre-primary school. Pre-primary school.
Item number 5.
Much obliged, Lordship. Much obliged, Lordship.
Yes, Mr. Sheikh.
Yeah. To appear through VC, Lordship.
What's the matter about?
I have no idea, Lordship.
This is regarding school teacher.
Yes, I can see that. Salary.
Yes.
Ms. Khat, what's your name?
Ellen Aring.
Ellen Aring, issue notice. Mr. K. Bharatsaji, CA, accept notice on behalf of 124. Steps to be taken in 3 days to other respondents. List up to 3 weeks, yes. For instructions to affidavit.
Item number 6.
Is the matter settled? Yes, Mr. Momin?
After instruction.
No instructions.
We have instructed our client to approach the MD of the MTC. So he's trying to meet the MD, but he could not meet him. And then we have not get any.
When did he try? Any letter given? You have anything to show that he's approached MD?
No, he just go by himself to the office of the MTC.
That kind of submission, this matter is only settled for other similar situated people. This is matter for 2 weeks on the prayer of the counsel of the petitioner to enable him to obtain concrete instructions.
7.
The rest after 1 hour.
Sure, so far as in item 7, we had filed a rejoinder on Friday.
Already filed it?
Lordship.
It's not recorded here in the order sheet.
I had filed on Friday, Lordship.
Yes, list for hearing.
Lordship.
Yes. Any other pleadings are complete?
Pleadings are complete in item 7.
Pleadings are complete. This is matter for hearing.
Now in item 8, Lordship, only the respondent number.
Yes.
Item 8, I am for private respondent number 7.
You're not filing affidavit?
Not get in touch with him. I'll file my
No, there's no question of not getting in touch with him. Those issues won't do. We'll close it. How many times you've taken Mr. Bhattacharjee?
Lordship, more than 7 times.
Yes.
Me?
Last order by 31/10/2023, counsel sought for further time to obtain instruction from respondent 7 to file affidavit. Today, no affidavit has yet been filed. Currently, affidavit by respondent 7 stands closed. This is a matter for hearing. You filed a joinder?
Your Lordship.
Yes.
Obliged.
Yes. We'll reconvene at 2.
7, 8, 9. 7, 8.
Yes.
May it please your lordship. So far as state is concerned, your lordship, this matter we have filed affidavit.
I've also filed my affidavit for respondent number 5 to 7, 10 to 13.
8 and 9, what happened? None appears. 8 and 9 is management committee. 8 and 9 are which respondents?
Private respondent, Your Lordship.
Yeah? Management committee does not appear. Number 14, you taken fresh steps?
Yes, Your Lordship.
Double receives. Okay, what two was 8 and 9? When were they served? You filed affidavit of service?
Yes, we have filed, Your Lordship.
When were they served? Just take out the date.
On 7/08, Your Lordship. 7/08. 7/08, Your Lordship. August.
7 August. See, like that. Ms. So-and-so submits that though response 8 and 9 have been served since 7th of August, today also no appearance has made on their behalf. Stop. You let it go as party against them, or they are necessary party? Let it go ex parte against them?
Another chance may be given.
Another chance for him to appear?
Yes, Lordship.
But however, he prays that as their presence necessary, perhaps one more opportunity be allowed. Stop. He also submits that fresh steps will be taken as part number 14. However, service reports levied. Stop. Accordingly, this matter after 2 weeks for appearance 8 and 9, and for service report is part number 14. Apply.
Then.
May it please Your Lordship. Your Lordship, as per the last order, we have to file the affidavit. My Lord, we will be filing the course of the day, and copies have been supplied to the petitioner.
Where's the officer? Officer concerns to appear in person if the affidavit filed.
It's in the process, Your Lordship. We'll be fine today.
What do you process? Now it's already 2 o'clock. Have you served a copy?
Yes, Your Lordship. We just received.
What did they say in the affidavit?
We just received this minute ago, Your Lordship.
That's right, sir. Mr. Jirenja submits that affidavit we find the course of the day. A copy of the same is, and submits a copy of the same has also been made over to the counsel of the petitioner. This is a matter of the 1 week.
Your Lordship, if you can file a rejoinder to this affidavit.
After 1 week, let's see what they say in the affidavit first.
Okay, Your Lordship. Much obliged, Your Lordship.
Yes, Mr. Pandey.
Lordship, herein DCRG is paid to retiring deficit teachers, Lordship. Even though service book is not available, Lordship, and I am to be partially blamed for it.
The same one? The same key as missing service book?
Lordship.
What are we to do?
Lordship, the factum of my service is not in dispute, Lordship. My humble submission is that neither of the respondents have disputed that I was...
What is the last paid on?
That will be available with the school, Lordship.
I'm tired of going around circles like this. Yes, Mr. Prasad, how will you resolve it? You're for the school, correct?
Lordship. The service records and everything was handed over.
Again, you don't make sense. How will you resolve? How will you resolve the matter? This is not a matter for any education or law.
Whatever comes, Lordship.
Whatever comes from where? He's lost a service book. You don't have any records with you.
It's the petitioner we approach and we hand it over to them, Lordship. It's not to the third person. That's the.
Lordship,
so you have to forego all your benefits. That this latches in the part of these petitioners of the deceased employee's son, correct?
Lordship. Then he was the one who collected, Lordship. But then, Lordship, I accept, Lordship, my culpability as far as accepting the service book is concerned. But then schools cannot escape the liability, Lordship.
Can you fix some notional amount?
Lordship, even we have already paid during his retirement 2,50,000.
So he's not entitled anymore.
Lordship, that was already paid to him during his retirement.
That was from the school fund, Lordship. That was not DCRG paid by the government.
How we to know now? Records all missing.
Lordship, that
your word against his.
Lordship, that is in my that is there in their affidavit also. From the school fund, they paid 2,50,000 rupees, but DCRG has not been paid, Lordship.
Yes, anything to say?
Your Lordship, we are handicapped, Your Lordship, without the service record.
Exactly. How will they compute your entitlements?
Lordship, if I'm allowed to make one submission, Lordship, as far as my limited knowledge is concerned, Lordship, a flat amount of DCRG is paid to the retiring teachers, Lordship, deficit teachers.
I don't know about that.
Lordship, I may be allowed to bring one order, Lordship.
You can't continue like this. You will let it take instructions. You bring some, if you can bring some order, some memorandum, some that shows that.
Lordship,
as per this matter for 3 weeks, Mr. Pandit to obtain instructions as to the amount of DCRG that may be payable in such situations. Yes.
12.
Highly obliged, Lordship.
Lordship, the counter is awaited there, Lordship.
Yes. What happened to counter?
Lordship, we have received instructions. Further instructions are awaited, Lordship. That's why we could not prepare the affidavit.
What instructions have you received?
To the extent that...
What's the matter about? Mr. Sheikh, school matter?
Lordship.
To the extent that the matter has to be taken up with the Finance Department, Lordship.
Yes. Yes, Mr. Sheikh.
Yes, Lordship, here after the date of my first wife, Lordship, then I put up the application for as a nomination in my service records. They are saying that no, my wife is not entitled to be nominated in my pension papers. That is the issue, Lordship. I am still alive, Lordship.
You're still alive?
The petitioner is my husband.
Right.
Hello. Your Lordship.
You file it in 1 week. Yes, MS.
Lordship.
EB Pasa. Yes, so please allow further 1 week's time to file affidavit. So, MS EB Pasa submits that the affidavit on behalf of number 4 has already been filed. Yes.
Much obliged, Lordship.
13.
My Lord, I will be filing rejoinder tomorrow, my Lord.
Tomorrow?
Yes, my Lord.
Mr. Jha submits that the rejoinder be filed in 2 days' time. This after this the matter after the organize the matter for hearing in the meantime.
My Lord.
This time there is a matter of hearing usual cause. Yes.
14.
Yes, Your Lordship. Lordship, in last occasion, this Honorable Court has directed for report from the Police Department regarding the 2 FIR filed by the petitioner.
Your Lordship, as per the last order, I was supposed to take instructions regarding the FIR that has been filed by the petitioners here, Your Lordship. Your Lordship, I've received instructions, and as per instructions, Your Lordship, an inquiry was conducted into the matter, Your Lordship, and they could not corroborate the allegations made by the petitioners here, Your Lordship.
What FIR do you file? What is in the FIR?
Your Lordship, they're saying that they were the petitioner here was intimidated by some of the private respondents, Your Lordship.
Where's Mr. Shongman? Is it a copy of the FIR? Let us see.
Your Lordship.
It's not a copy of the FIR. Yeah, with you? No.
Your Lordship, since I'm not in a position of argue the matter,
I have the FIR, Your Lordship. It's in Khasi.
Who is appearing for respondents?
I'm appearing for respondent number 5, Lordship.
What's your name?
Lordship, I'm for the-
Rosmandar Nongsej.
Yes, Lordship. I'm for the Darbarshnam, Lordship.
You're Rosmandar Nongsej.
No, Lordship. I am.
The private,
I'm in fact the
the
Sordar,
private
Lordship.
individuals have not been named, Your Lordship. Yeah.
Roy Linkoy, Lordship.
Then who's this Rosmandar Nongsej and West Keldeng's Swang? They were
They're
taken for
not
questioning.
Party, Your Lordship.
They're not included in this
For
case,
questioning or
Lordship.
not?
They were questioned, Your Lordship.
Then, what did the police say?
Your Lordship, they said that these people were also just walking back back home, and it so happened that the petitioner was.
You will not make such FIR if they have.
Your Lordship, I can, if permitted, I'll file a status report, Your Lordship, and I'll bring it on record.
No, Lordship, what has happened in this case, Your Lordship, these people, under guise of filing this writ petition, and they have taken over the administration of, indirectly taking over the administration of the village, Your Lordship.
Oh, the petitioner?
And now they are filing police FIR, one FIR after another, Lordship, without being able to substantiate it. In fact, Lordship, in this case, pleadings have been completed, matter is fixed for hearing. And they are now coming up with this FIR, which is not connected with this matter also, Lordship. These people are not included in this.
Is he a resident of your
He's
village?
Perhaps, Your Lordship, but this is a separate matter, Your Lordship. Here, in this case, pleadings are completed. In fact, we are for the hearing, Lordship. We have placed on record several aspects to this matter, Lordship.
Your Lordship, if I may submit, Your Lordship, Rosmandar Nongsej is the victim, Your Lordship, here, who had fallen ill, and the petitioner was called to his house, Your Lordship, because they had alleged that there was some.
So he chased this petitioner now.
That's what they're alleging,
With a
Your
cookery.
Lordship. That's what that's what the petitioner is alleging, Your Lordship.
Okay. Pursuant to the order dated 31/10/2023, Ms. Zeri Nonkari submits that she received instructions. She prays that she'll praise the same. Please within 1 week.
Yes, Your
that the
Lordship.
entire matter appears for hearing thereafter. Yes.
Obliged, Your Lordship.
Not day after, thereafter.
15.
Please, Your Lordship. Lordship, here I am appearing for respondent number 4, Lordship.
No more time.
Pray some more time, Lordship, to file my counter, Lordship.
You receive in my case, they are not giving my current salary also, you receive.
How much is due?
Let the affidavit be filed, my lord.
Why?
We have, from the state, my lord, we have filed a affidavit.
Lordship, I need some more time, Lordship, because I have applied for.
How much more time? Two days
some
time?
documents and RTA, Lordship. 3 weeks, Lordship.
You receive.
Since when you have not been paid?
3 weeks, Lordship.
Since long time, you receive.
Since when? A long time means from where? From the time he was born. And
No, my lord, there is here also two dispute between two teacher, Lordship. Dispute between two teacher, Lordship.
It's a long time. You don't even know. You see,
And
no,
he is not.
You should know. Listen, you don't know
And he is
exactly when he
not-
was paid from.
And he is not attending the school also, Lordship.
So, receive, this is 2019 onward, this payment was there.
We are disputing.
2019.
Since 19?
2019 onwards, I have given.
Not been paid?
Yes. Or now also, the current salary to them not released.
Very unfortunate.
So, receive,
Yes,
whatsoever
let him file
dispute they are
affidavit
seeing.
then. You don't not even
current
aware of
salary
it.
is- They'll
Yes, let them file affidavit and we'll decide. Yes, okay. Mr. S.I. Sheikh prays for and allowed a final opportunity of 3 weeks to file the affidavit.
3 weeks, Lordship.
Yes. Oh, 3 weeks, yes.
16.
Yes. Pass, Lordship.
Yes.
Wait, please, Your Lordship. Your Lordship, here I've sought for additional instructions from the department, Your Lordship, so I pray for
What's the
something.
matter about?
Promotion matter, Your Lordship.
Okay, 2 weeks further time as period allowed. The government advocate for affidavit, yes.
Obliged, Your Lordship.
17.
Your Lordship, I need further 2 weeks' time, Your Lordship, to file my rejoinder.
How many times have you taken?
This will be the third time. By next time we'll file.
Final opportunity granted to the petitioner to file rejoinder affidavit. This after 2 weeks.
Highly obliged.
We're not giving time after this. Rejoinder is not by right.
18.
File affidavit.
You received it?
Yes, Your Lordship. I pray that may be allowed 2 more weeks, Your Lordship, to file a...
Yes?
I pray that I may be allowed to file a rejoinder, Your Lordship.
Okay. Petitioner prays allowed 2 weeks time for rejoinder affidavit.
Hearing. Item 21.
Yes.
May I please, Your Lordship? Today it's actually fixed for hearing on the point of jurisdiction, Your Lordship.
Yes.
But my humble request before Your Lordship that this matter may be placed before another bench, Your Lordship.
Why?
Your Lordship, I humbly submit that...
I appeared this matter before.
No, Your Lordship...
Why is not on the bench?
Your Lordship, I'm not comfortable to do the hearing before this bench, Your Lordship.
Why?
As Your Lordship's associates are also like standing counsels for GHADC, so...
No, that is not a consideration. They get you mean to say that no negative orders have come against them. You see, there is not a good submission to make.
I apologize.
We're not influenced. We're sitting here. We're not influenced by anything. That is very unfortunate. You ask them, they're getting more negative orders, I think, from this bench, GCDC, than from any other court. Yeah, but since you want that, then as counsel reservations about this bench, this matter is before any other bench around me. Very unfortunate, MS Shilla, yes.
22.
Yes. All represented.
Well, Mr. Gautam.
Yes.
May I please, Your Lordship? Your Lordship, here we are challenging the illegal and arbitrary action of the respondent number 1 in appointing respondent number 4, 5, and 6. Your Lordship. Your Lordship, in the year 2019, an advertisement was published, Your Lordship, which is at Annexure 1, page 31, Your Lordship. Page 31, Your Lordship.
Yes. 1 second. Yes.
Your Lordship, may I read? Applications in prescribed form are invited for filling up 3 vacant posts of Magistrate First Class Subordinate District Council Court, KHDC Shillong, in the initial pay scale so and so. Your Lordship, kindly note here that the that the post was 3, Your Lordship. Thereafter, Your Lordship,
The 6th November.
dated 6 November 2019, Your Lordship, for the post of Subordinate Magistrate District Council.
Okay.
3 posts, Your Lordship. Thereafter, Your Lordship, applications were filled up and 6 candidates were called for interview. Out of that, Your Lordship, the 3 people have already cleared, Your Lordship. That is in Annexure 4, Your Lordship, page 34.
After Annexure 2, Annexure 1, no?
So, Your Lordship, Annexure 4, Your Lordship, I'm referring now. Page 34.
Yes.
Out of the 6 people who have given interview, Your Lordship, the first 3 have secured a highest mark and they were ranked in the order of merits. 1, 2, 3. And waiting list was also there in the said letter dated 11 January 2021, Your Lordship. Thereafter, Your Lordship, the first 3 candidates was duly appointed and have joined their respective office and are still serving, Your Lordship. None of them had vacant their seats, Your Lordship. Your Lordship, thereafter, on 19th August 2021, Annexure 5, Your Lordship, page 35, the respondent number 1 wrote a letter to respondent number 3, Your Lordship, stating that, may I read, Your Lordship? In inviting a reference to your letter dated 4/3/2021 on the subject above, the executive committee has appointed Shri so-and-so, Shri so-and-so, and Srimati so-and-so. These 3 people have already joined, Your Lordship. However, next para, it may be informed that there are few more vacant posts of magistrate first class as per current budget provision, Your Lordship, and in view of the current situation in the state and country as a whole, it may not be conducive to conduct fresh examination for filling up the said vacant post. Your Lordship, kindly note here that the respondent number 1 here is admitted that there are few vacant posts, but due to the current situation in state and country, they do not want to conduct fresh examination. Full stop. The executive committee has, for strengthening the function of the District Council Court, recommended to fill up the remaining vacant post from the candidates in the waiting list. Moreover, there are many pending cases which require speedy trial, and the executive committee is also contemplating to make the District Council Court functional in all district headquarters, namely Nongstoin, West Khasi Hills, Nongpo, Ribhoi, and Mokowat, Southwest Khasi Hills. Therefore, it is once again requested to fill up the remaining vacant post candidates in the waiting list per notification 11 January 2021 may as a special consideration be approved for appointment of magistrate first class as follows. Those are respondent 4, 5 and 6, Your Lordship. So here, Your Lordship, the respondent number 1 has requested respondent number 3 to fill up the post as a special consideration. Here they did not say that they have issued a new advertisement. They have just given the reason that due to the situation in state and country. And also it may be considered as special consideration, Your Lordship. Thereafter, Your Lordship, the respondent number 3 in a letter dated 25th October 2021, Annexure 6, Your Lordship, the next page.
Yes, yes.
May I read, Your Lordship? With reference to the letter and subject cited above, I am directed to convey the approval of Honorable High Court for appointment of 3 candidates from the waiting list as per notification number so-and-so dated 11 January 2021 to the post of Magistrate First Class Subordinate District Council in the KHJDC Shillong. So, Your Lordship, the respondent number 3 also...
Now, who are the petitioners first, MSJ3?
Yes, Your Lordship.
Who are the petitioners?
Petitioners, Your Lordship, both of them are practicing advocates, Your Lordship.
They sat for selection?
Yes, Your Lordship.
What is their position not known?
Sorry, Your Lordship?
What is the position not known in the selection?
No, Your Lordship. They participated and however...
Were successful?
Yes, yeah.
They didn't qualify in the written.
They didn't qualify. They participated. Petitioner number 1 qualified in the written, Your Lordship.
Petitioner qualified in the written, but then didn't get through the interview.
Yes, Your Lordship. Your Lordship, here the respondent number 3 also did not verify that there is no fresh post or fresh advertisement.
Number 3 did not?
Did not verify, Your Lordship, that there is no fresh vacancy, no fresh advertisement.
So the only ground taken is that because they cannot hold when they view the current situation, it is not conducive to examinations. and to fill up the post.
Yes, Your Lordship.
That's all.
The main contention of respondent number 1 was due to the current situation of state and country as a whole, it may not be conducive to conduct fresh examination. Just because of that reason,
that's the only thing.
that is the main reason which respondent number 1 has given, and the respondent number 3 has also approved their appointment as a special consideration.
So, and they joined in 2022.
Yes, Your Lordship. All of them have joined in year 2022. Your Lordship, if I may take you to page 38, Annexure 8.
Okay, yes, Annexure.
Annexure 8, page 38, Your Lordship.
Yes.
The respondent number 1 have written a letter to the Joint Secretary, which is respondent number 2 here.
Yes.
May I read, Your Lordship? I am directed to enclose herewith a copy of the approval by the Honorable High Court of Meghalaya for the appointment of the above named 3 candidates to the post of Magistrate First Class Subordinate District Council Post, Khasi Hills, White notification dated number so-and-so, dated 11 January 2021, for favor of onward approval by the Honorable Governor of Meghalaya, and also for conferment upon them with the powers as provided under Para 1, Subclause 1 of the 6th Schedule of the Constitution of India, and for publication or notification thereof. So hereafter, after the approval of Hereafter, the approval by the Honorable High Court of Meghalaya, a letter was sent to the respondent number 2, and whereby they have enclosed here that the High Court has also approved. And seeing this, the Governor of Meghalaya that have also approved their appointment, which is Annexure 9, page 39, Your Lordship. In exercise of the power conferred by sub-rule.
Okay.
Yes, Your Lordship. The Governor has also approved, seeing the approval given by the Honorable High Court of Meghalaya.
Where does it say?
Sorry, Your Lordship?
Where do you see that seeing the okay?
Annexure 9, Your Lordship.
No, it's just a copy of approvals annexed.
Yeah, approval. Yes, Your Lordship. The Governor has also approved.
Yes. So now your case is that if they not advertise a post, they are stopped from accommodating any other candidates to appoint them to other vacant posts. Correct?
So sorry, Your Lordship.
No, I think that once the advertisement is given for 3 vacant posts,
yes, Your Lordship,
they're not free to appoint anybody
apart from
over and above the 3.
Yes, Your Lordship. Okay. Your Lordship, only 3 posts was advertised, but they have put 6 persons in the set 3 posts. That is the illegality. They could have advertised a new vacant post, Your Lordship. Then advertisements would fill.
Fresh selection process.
Yes, Your Lordship. Yeah. After the approval from the Governor as well as High Court of Meghalaya, the respondent number 4, 5, and 6 were appointed, Your Lordship, and they have also joined. Their joining report is also annexed, Your Lordship, in Annexure 13, 14, and 15, Your Lordship, respectively. Seeing all the thereafter, Your Lordship, they resumed their office, and after having known that they have resumed their office, representation was also sent, Your Lordship, to respondent number 1, which is Annexure 16, Your Lordship.
Yes.
Page 46.
What did they say? They didn't reply.
They did not reply to the representation, Your Lordship. As such, we had filed writ petition here, the earlier round of litigation, wherein this Honorable Court was pleased to issue notice, Your Lordship. And after, in the second,
what is RTI queries?
Queries was just a minute, Your Lordship. Your Lordship, the RTI queries was It's at Annexure 17, page 56, Your Lordship.
No, where are the answers? What are the queries?
Query was, question was whether the executive committee has
Did they
recently...
answer the queries?
No, Your Lordship, they did not answer to the...
Why?
I'm not aware of that. The respondent one is in the position to answer that.
No, why? They never answered.
They never answered, Your Lordship, to our RTI query also. That's why we had come before this Honorable Court by another writ petition, whereby after entering appearance, the respondent number one had given the copies in the court itself. Then, Your Lordship, I have prayed for withdrawal of the matter and I have filed this fresh matter, Your Lordship.
Why you withdrew the earlier matter?
Your Lordship, since new documents were given to me in the court, Your Lordship.
Okay. Yes.
Your Lordship, my main contention, Your Lordship, is that the respondent number could not have appointed the respondent number 4 and 5 and 6. They've given a back entry door, Your Lordship. Since the post advertised in the year 2019 was only for 3 posts, Your Lordship. And in the 3 posts, 6 people are sitting, Your Lordship. And the only reason which the respondent number 1 has given that due to the current situation in the state and country. So this may not be a ground, Your Lordship. As such, I'm praying for termination of the appointment of respondent 4, 5, and 6, Your Lordship. And regarding waiting list, Your Lordship, the waiting list was also extended. However,
it was extended by the respondents.
By
the select list, you mean?
Sorry, Your Lordship?
You mean the select list?
The waiting list, Your Lordship. The waiting list was extended. It is in Annexure 7, Your Lordship, page 37.
Waiting list or the select list? Waiting list.
Waiting list.
Annexure?
Annexure 7, Your Lordship.
Annexure 7, it says validity of the list.
Validity of the list. And waiting list is also there, Your Lordship.
Select list means it will contain the candidates, selected candidates and yes.
Yes,
6 September 2021.
Yes,
it was extended till 1 year.
31st March 2022. But however, my argument would be that the said extension will not have any effect to their appointment. Because, Your Lordship, until unless the first 3 candidates who have already sat in their position, Your Lordship, if they vacant or if they demise, then only the waiting list. Yes, Your Lordship, that is my only ground. So I would humbly pray that.
Where's your give me authorities? What are these affidavits?
Affidavits, Your Lordship.
You brought the authorities in support of your case. That's all.
Your Lordship, I will come to the affidavits.
Now, what about authorities in support of your case?
Authorities.
Yes.
Your Lordship, actually.
You take all authorities that show that what they're doing is absolutely illegal, and the reason given is not sustainable. You brought authorities?
Your Lordship, today actually I have not brought the authorities. I would give compilation of the authorities.
See, if you come for a hearing, you have difficulty, you should let the court know in the beginning. Sorry, 2:30. You prepare, you come back. You also prepare because finish this matter. MSP Chetri, after hearing some like MSP Chetri seeks some accommodation to enable her to prepare the matter better. Just after 1 week. Yes.
24.
Oblige.
These are MUCL matters. These are batch of writ petitions.
Where's the respondents? Yes, MSZE, where?
Your Lordship, Ms.
Our colony.
Is on her legs, Your Lordship.
Yes, for what today?
On the last occasion, the
What
other
is for today?
AG has furnished the list of those employees
Yes.
where 50% of the LEB has been paid.
Your Lordship, I believe that they want to seek an adjournment, Your Lordship, as the
Who?
MECL, Your Lordship, as Mr. Ahmad Kumar will be leading them, Your Lordship.
No, they are supposed to come up with some instructions. They said that a list has been produced and and a copy is all made to them, whether it's correct or not, have you verified?
The copy was never supplied to us in the first case.
Why?
To release the amount, no?
Your Lordship, I'm handicapped. Ms. Colney will be in a better position.
You not receive a copy?
No, my lord. No,
But on
no,
the
I've
court,
I've received instructions from my client.
Ms. Singh, you receive a copy that day?
Not in my case.
Who took a copy?
There are many matters.
You sure? Then why should the court record that? A copy received and made over to the Council of Petition.
Matter after a week, my lord, and dispose ultimately, my lord.
No, see, you're supposed to see that list, you understand? You understand what the court is saying? Last time we produced that list, indicate leave and encashment benefit with effect from 17 to 23, which have been given to our employees.
Half of the amount. They said they have released half of the amount. So.
They didn't say half the amount, he said it's been released.
50%, my lord.
50%.
We have inquired from a client, they said we've received 50% of the
50%
amount.
they have released. That is what their submission also.
My lord, we seek further time, my lord. We are adhering to the schedule which we have filed through an affidavit, my lord. And so far as the leave encashment, my lord,
Benefit.
LAB, that 50% which we have undertaken, my lord, that has been cleared till the month of August, my lord. We have cleared, my lord.
August of 23.
Yes, my lord. That is the last data which have been given to us by the corporation. So, my lord, we are
You
clearing,
have been
my
paid till
lord.
August 23?
Yeah.
No, my lord, as per my instructions, we
have
have
no
received
idea.
only in the month of May, Your Honor.
So they are the first people who have received, my lord.
50% of the
because
LAB.
This is not particularly for the petitioner, for the entire employees, my lord, LAB, which we have undertaken.
So what's the court to do then?
My lord, only submission.
Matters that they're not, nothing to adjudicate on law.
Exactly, Your Lord.
It's like
Exactly.
bargaining table.
Yes.
Using the
Yes,
court as a bargaining table only.
Lordship, my lord, there are analogous matter where I am also appearing, Your Lordship.
Yes.
My only concern, my lord, Lordship is concerned, my lord, about the financial health of the MECL. Now, some kind of, my lord, via media is trying to be sorted.
Court is not concerned. It's concerned to the extent that if we enforce payment, it might break the whole corporation. That
No, I understand, my lord.
That's the only thing.
And
That
we
there
are
must
also,
be some
we are
media where employees also are not exploited or they're not deprived, and the corporation also can run.
Exactly, my lord. But only thing I am pointed out, Your Lordship, these are our entitlement, my lord, basic social security, Your Lordship. Now we are also cooperating to the. My lord, Lordship is, my lord, fully. These are the rights. Now, my lord, we are also fully cooperating. They are paying in increment. We have accepted the 50%. Now, my lord, things we cannot face this uncertainty. My lord, when the rest will be paid. Now, only submission comes from the MECL that we have prepared a list. This is the budget. We have prepared a schedule. You cannot jump the queue. Well, how long it will go on like this?
My lord,
It cannot go on forever like this, Your Lordship.
In the affidavit, my lord, we have stated that within a period of 2 years, that is what we are trying to sort out.
That is also what we are
now,
trying
my lord,
to.
We are completing the first year, perhaps, my lord, and the 50% which we have undertaken also, we are at the point where we have cleared, my lord.
It cannot go on like this. My humble submission, Your Lordship, take a final call on this thing. 50%.
Who will take a final call? Will it come lead to contempt?
My lord,
No,
exactly.
Lordship.
Will you pass when you have conclusive orders?
No. I'm not saying this, Your Lordship. Because they are bound to pay. They cannot say
They are
that.
bound to pay. It's very sensitive to post-retiral
Lordship will
entitlement.
see, is it our right, my lord? If it is a right, we are before the court, my lord, court will enforce the right.
If I may please, my lord, to please record one article published by the Meghalayan, my lord.
What do we do to article? We don't take cognizance of. We don't take cognizance of articles.
Yeah, my lord, sufficient grants has been provided to the MECL to the tune of ₹40 crores monthly, my lord. That includes for pension, salary, and for.
Have you taken that? Have you that on based on news report?
My lord, this is the statement given by Power Minister, my lord.
And here the other problem is.
Something, Mr. Sangma, even to include in the tariff, so that the pension liability will be met. Also, even that is not being done. You see, so how do you expect the corporate to survive? Also.
Now, my lord, here as per the affidavit, is stating that the remaining LEB.
My lord, some requests were also made to state government for some grant and aid also. That also has not been approved yet, my lord. So this is a difficulty which the corporation is also facing, my lord. However, with whatever undertaking which we have made in the earlier occasion, we have been clearing also, my lord. So I believe my friends also have not disputed.
There is no clearing except 50%, nothing has been
50%,
paid.
that is what we have been given the undertaking, my lord.
That was only leave encashment. What about the gratuity?
My lord, that is what we have said within a period of 2 years.
You don't have a copy of this list?
Well, we have not received.
We have enclosed in the affidavit, my lord.
Have we received? Well, we have not received.
It's not the
We
affidavit.
do not know, so what is this?
That is a document which...
No, this is last time it was recorded that. Where's the order sheet?
My lord,
You just produce the list. Otherwise, you take a copy from the registry. Let them take a copy. The council submit that the list submitted on 20th of October has not been made. They have not. Council does not receive a copy of the LEB list with effect March of 17 up to 2023. There are how many employees here? How many are before the court? 8 and 12 here.
Around 13 or 13 to 14.
16, my lord. There are 16 petitions before your lordship.
But there is a case filed by the association also.
The association has gone separately.
that is separately.
Huge amount. Let them take copies, please. Yes. From from March, August 2023, which was produced before the court last occasion stopped. They are permitted to obtain a copy of the same from the registry. 521 crores already paid. All corporations, councils, all become sick. Now, how many cases? GHADC also, GHADC, municipal corporations, everyone from the state, all asking with a begging bowl from the state. When will the situation ever resolve?
This matter will lordship come up next week?
Yes. No, let's after 2 weeks, yes. Get copies.
The only thing I'm hearing that vacation comes, long vacation, they will go to next year.
Helpless. These cases shouldn't be, they should go to some other kind of tribunal, you know. This pension or, you know, graduation tribunal. They should have appoint one-man tribunal. You know, the government should appoint one man, then the grievances should go there. Then if they can't be settled there, then let it come to court. Otherwise, what's the point, Mr. Sitting here, passing orders, so just put them in difficulty.
Even before Lok Adalat, several times matters were placed, but there also...
No, that's why we had a pension adalat. That's why that was, in fact, on our initiative. We asked the departments how many pension cases are pending, please come here. And that day, in fact, that means we stopped around a few hundred cases from coming to court, you know, by being settled there in the pension adalat. We asked responsible officers to come who can, you know, sit across the table. And you can't have people running pillar to post. Yes. Pensioners don't have any money. They won't be able to pay the house rent also. Exactly. They can't come to court, no? Exactly. How will they come to court? And they are already financially very stressed. That's why we had a pension adalat. This one also maybe will fix MECL adalat. You know? Specific adalat for MECL, yes. Then really, we might take it there.
But only problem,
so there will be no appeal from any orders that are given.
The officer, whoever comes and represents the MECL, he
I have no authority. No. When we have adalat, we'll make sure. Like we did last time, we made sure that if a person does not come who has authority to, you know, to disburse or to give his what do you call it, a competent authority doesn't come, then we will take action in the department. So they send, the right officers, yes, and they came prepared also. So some matters could not be resolved because usually we have so many 1, 2, 3 wives fighting. So those things are left for other things. But the other matters which, delay and all those are all resolved. Yes.
Madam, there are 16 item numbers, madam. Item number 24, 28 to 42.
Okay.
28 to 42.
Now, really, we should have one for MECL only.
25.
Where's Mr. Nyuta? Yes.
Yes, Your Worship. This is a social boycott, Your Worship. And Your Worship, the reason for social boycott.
No, last time we passed orders. Why? But last hearing, what happened?
Yes, regarding with inquest, Your Worship.
To send to the civil court.
Yes. At what stage is in the civil court in the title suit?
Now, deposition, yes.
Deposition is going on?
Yes.
So, have you filed a miscellaneous application in the
Yes,
civil
yes,
court regarding this matter?
Yes, yes.
Regard to ingress, have you filed?
Oh, no, yes.
You have not filed? No. Let them file, Mr. Karshi.
The thing is, my lord, we are not blocking any ingress.
No, let them file.
Okay.
And then there will be supplemental proceedings. So let them file one application there, and then you issue notice, and then you go for local inspection from the court itself, and then you see if you're blocking it, then you'll have to remove it. If you're not blocking it, then he has to keep quiet. You agreeable to that?
Yes. Even though I'm not pressing about the merits of the case regarding with the.
We're not talking about merits. We're talking about the cause for sitting in 226. We can't decide this matter. See whether your road is blocked or not.
And moreover to that, my lord, the particular land is only measuring only for 2,400 square feet. 2,400 square feet, which the Darbar Sunong is a rewrite land we give to the petitioner.
But Your Lordship, in that document, the boundaries, Your Lordship.
That is
nowhere to show, Your Lordship. There is nowhere to show that the right.
No, we're not going to see. Ms. Karshi said we're going to do merits. Now he's talking about the merits.
See, that's
since he's making this submission, Your Lordship.
With one hand he's giving this, one hand he's doing that. No,
yes.
you can't. You see not merit, no merits. It's only on law, yes. which is the way out. That's all.
Yes,
that's all. Nothing. Or whether.
And Your Lordship, with regard to social boycott.
There's no social boycott, my lord.
Since in his.
Where's the state?
No, district council is there, Your Lordship.
District council is here, Your Lordship. 123, Your Lordship.
Even though in his affidavit, Your Lordship, he said that there is no social boycott, Your Lordship. But on the other hand, Your Lordship, he.
Yes, okay.
Merely allegation, my lord.
Just because there is no proper register, Your Lordship, record and all. There is no signature and all. You just fill up the name, Your Lordship. He can easily manipulate it, Your Lordship.
Okay, take down. The petitioner had approached this court. Has approached this court by way of the instant writ petition. Against alleged discrimination, harassment, and social boycott. Alleged, which the petitioner and her family was said to be suffering from. Stop. It has been contended that, oh no, it has been, what I contended, stop, harassment, no?
The petitioner had approached this court by way of the extent that petitioner against alleged discrimination, harassment, and social boycott, which the petitioner and family was said to be suffering.
At the hands of the respondent number
4
and the Darbar.
No, yes.
Only number 4.
Yes. Only he has given a call to the in charge.
Yes, number 4, who is stated to be the headman of the Rasat village, Umkse, East Kasil district. Stop. It appears that there is also a dispute, a civil dispute between the parties, that is petitioners number 4, for which a title suit being title suit number 94 of 2022, along with the miss case, are pending adjudication. The challenge, the writ petition, the present petition before this court, as per the contention of the writ petitioner, the present petition to court, as it was when it was filed, is only with regard to the said social boycott and the non-inclusion of the petitioner's family in the social beneficial schemes, correct?
No, Your Lordship. The scheme regarding with the scheme and all which was under the BDO jurisdiction, Your Lordship, he not interfere, Your Lordship. We are not disputing that.
No, nothing.
The present petitioner for this court when it was filed is only with regard to social boycott and non-inclusion of
No, social boycott and discrimination. Stop. You file affidavit saying there's no social boycott, right? The respondent before, who thereafter entered appearance, has categorically stated in the affidavit that there has been no threat or there has been no social boycott, discrimination, or any threat of demolition of the house of the petitioner, and that the petitioner and the family are welcome to take part in all the social activities that are being held in the village. Stop. In said affidavit, instances have been narrated to show that the petitioner and a family have not been discriminated and have taken part in social events such as funerals
and contempt.
And my lord, Annexure D also is the daughter of the petitioner, is the founder of the self-help group. It's clearly mentioned in this.
From
in the said affidavit,
instances
have been
narrated
to show that the petitioner and the family has not been discriminated
and that they've taken part.
in social events.
It has also been submitted by the counsel for the respondent that the daughter of the petitioner is also.
That regarding with that, Your Lordship, because that self group was created before he took over the head of the office.
Okay, we won't add it then. Let's see all the orders. Did the EDM come to the village? No.
No.
This is not the case, right?
No, no, before this case, if I'm not mistaken, before the, yes, my lord, EDM, which is, the order also is there in annexure.
Police report is there, Your Lordship.
Yeah, where's the police report?
Police report is not here, Your Lordship, only the other part of the magistrate, Your Lordship.
Yes, that's what. Where is that? In the petition?
Annexure B, my lord, page 13.
Affidavit.
My lord.
Annexure B.
My lord, page 13.
Oh no, forget about this. Don't bother about this. Stop. As the case progressed, stop. As the case progressed, the petitioner has brought to notice of the court that the ingress and egress to the suit property in question has been obstructed by the respondent before by the construction of a small shed. Stop. The same has also been refuted by the respondent, who has maintained that this construction of the shed was on the private land, was on the land of the Darbar, and that the ingress and egress of the petitioner is not hampered in any manner. Next paragraph. Mr. D. Hunyanatala, counsel petitioner, has submitted that notwithstanding the fact that the shed may be in the land of Darbar Shillong. You see, it's in your land, no?
Yes, Your Lordship.
It's not in Darbar Shillong's land?
No, Your Lordship.
But the Hunyanatala has submitted that it is not a fact that the land, that the shed was constructed in the land of Darbar Shillong. And to buttress his argument, has filed an affidavit bringing on record certain photographs to showing the lay of the suit property, the lay of the land, that is suit property and surrounding areas. To this, he submits that he therefore has prayed that appropriate orders be passed by this court to ensure that the ingress and egress as enjoyed by the petitioner all along be restored. Mr. K. Kharshian, that counsel for the respondent before, has strongly refuted the submissions and has also filed an affidavit being record certain photographs to dispel the submissions, to try to counter the submissions and the materials produced by the writ petitioner. Faced in this situation, this court sitting in Article 226 jurisdiction is not in a position to adjudicate disputed questions of fact which have been raised by both the parties. In this view of the matter, therefore, as the title suit is still pending before the trial court, appropriate applications may be moved by the writ petitioner for orders as being necessary, which, if the trial court deems fit, may also order for a local inspection to be conducted. In the mean matter, as far as the minute petition is concerned, as it has been submitted categorically that the writ petitioner family are not subjected to any harassment, this court at this stage accepts the submissions but however will hold the respondent before accountable should any untoward incident happen of harassment or discrimination in any manner. It is expected that the necessary application for necessary orders with regard to the ingress and egress be filed most expeditiously by the writ petitioner, and the trial court, after due notice, dispose of the same also as expeditiously as possible. With the above noted directions, the writ petition stands closed and disposed of. Okay.
One small prayer, my lord.
Yes.
It may be kindly reflected that I also says that he blocked the egress and egress by himself.
I'm not saying that. I said that you said it's construct under Russian land. He said no. That's all. So that let you make a submission before the trial court. I'm not going into merits. I say it's just allegations. That's all. Correct.
And Your Lordship, I'll just pray regarding with the record register, Your Lordship, let the proper record be maintained, Your Lordship.
Yes.
Or else, like the register, Your Lordship.
Register?
Like the register for allotting the work and all, Your Lordship. Let the proper register be there. Or else, Your Lordship, the same thing happen. She just
see, if not there, then you come again and will take strong action, make him appear before you.
Again, Your Lordship, just
hold Mr.
without
Kharshian
submission or-
personally accountable.
Okay.
Yeah.
Hello.
Yes. Mr. Cloud, record on behalf of respondent so and so. Any submissions?
No, Lordship. It's regarding respondent 4 and the petitioner, Lordship.
Hello.
Right, Your Lordship.